Good morning, everybody. First of all, thank you for taking out time on a Saturday. She's a seasoned educator, she's the principal of Government Law College, and she has been immensely supportive in all our Chamber of Tax Consultant initiatives. So it's an absolute honor to invite you to speak.
Ma Saraswati La Vandan. All the dignitaries sitting on the dais of the dais. I must say, today is an auspicious day because it is the day to remember our former President of India, Dr. APJ Abdul Kalam, the educationalist and great scientist. GLC and CTC, that is Government Law College, and the Chamber of Tax Consultant. Jointly, we are organizing one-day workshop on the new criminal law, encompassing detailed discussion on Bharatiya Nagarik Suraksha Sanhita 2023, Bharatiya Nyay Sanhita, and Bharatiya Sakshyam Adhiniyam 2023. The inaugurator and the speaker of today's function, Honorable Justice Sandeep Shinde sir, former judge, Bombay High Court, Mumbai, Shri Kantawala sir, an advocate, all the governing members of CTC, all the professors who are present here from different law colleges of Mumbai, all the legal fraternity guests and postgraduate and graduate students of law. Very warm welcome and good morning to you all. I am receiving many phone calls. Being chairman of Board of Studies of Mumbai University, Mumbai, regarding the inclusiveness of these three criminal acts, criminal laws into the syllabus of LLB as well as LLM. I am stating them that these laws, new criminal laws, will be definitely the part of our syllabus and the university notification will come to you. All the formalities which are required from university side has been carried out and we as a teacher has to now teach BNS and BSA 2023 Act to our students. The main intention to have such kind of a workshop is to find out what is the difference between the earlier acts and the new amendments and the changes which has been brought before us in these new three acts. As you all know, Government Law College always tries to take a lead for such kind of a program. This college has been established in 1855. This is the oldest college of law in Asia a pioneer in legal education, an institution par excellence. The generations of legal luminaries who have been nurtured by this unique institution have made a seminal contribution to the evolution of Indian legal system. Dr. Babasaheb Ambedkar have all been the principals of this venerated institution. The first Chief Justice of India, Honorable Mr. Kaniya, was an alumnus of this college. Former Honorable Chief Justices of India, Mr. Kaniya, Mr. Bhagwati, Bharucha, all began their career at GLC. The Honorable President of India, Her Excellency Pratibha Singh Devi Singh Patil, the Chief Justice of India, Honorable Justice Kapadia Sir, Soli Sorabji, Fali Nariman Sir, Anil Diwan, Gulam Vahanvati, have all been the students of this institution. I am very happy to convey you that not only the 5 years and 3 years course we are running, but along with that we have started LLM, that is postgraduate course, and even the research scale in this research cell in this college. Not only that, but we are also conducting 5 add-on courses for the law students from first year to 5th year. So once the student takes admission here in the first year of the 5 years course, and when he finishes his course after 5 years, he goes with a bag of 7 certificates, 2 graduate and 7 certificate courses. Similarly, we are conducting 2 postgraduate diploma courses and 2 certificate courses. I am very happy to convey you that this is the only college which is ISO certified 21001-2018, and even it is NAC accredited very recently. Similarly, we have a very good association with the CTC. It is non-profit organization which aims at educating the students. They have we have very good association, and we are conducting the textbook too. And out of discussion, it was thought that why not to go with such kind of a workshop which will be helpful to the legal fraternity, and therefore we decided to conduct 1-day workshop based on these 3 criminal laws. We, in collaboration of CTC, also planning to have, sir, bata do? We are also planning to have planning to launch one more certificate course, which will be a unique kind of a thing, certificate course on income tax this year, and it will be open for all law students. This time, as I said you, we have decided to start the session with a workshop on new criminal laws with the motto to educate and highlight on these 3 laws, and also for elaborate discussion. The another intention is of course to prepare our teachers for teaching these laws. I am really happy and appreciate all law college principals for deputing their teachers and professors, and appreciate the presence of all the professors who are here for this workshop. I also keep on record that most of the students from the postgraduate and graduate law, that is LLB and LLM, they have also registered for this program. The 3 acts on which we are going to have the discussion, the first one is the Bharatiya Nyay Sanhita 2023. The experience of the several decades of Indian democracy called for the comprehensive review of our criminal laws, including Indian Penal Code, Indian Evidence Act and CRPC Act. I'll again repeat, Indian Penal Code 1860, Indian Evidence Act 1872 and CRPC with Amendment 1973. The first Law Commission was constituted in the year 1834. While the Indian Penal Code in 1860 was introduced as a substantive law relating to the offences and punishments. Since then, the Indian society has evolved tremendously in different aspects like societal, technological, economical and intellectual. The nature of crime is changed, over last few decades. Therefore, it was necessary to review the existing criminal laws with an aim to strengthen the law and order and to make existing laws relevant to contemporary needs of the society while providing speedy justice to all. A bill, namely Bharatiya Nyay Sanhita 2023, Bharatiya Sakshyam Bill 2023 and Bharatiya Nagarik Suraksha Sanhita Bill was introduced in Lok Sabha in August 23 by Amit Shah sir, Honorable Minister of Home Affairs and Cooperation. The bill was referred to the Parliamentary Standing Committee for its consideration. After due deliberations, the committee submitted its report on 10th of November 2023. Recommendations were considered by the government and revised bill was reintroduced in Lok Sabha in December 23 and in Rajya Sabha also in December 23 separately. After getting approval from both houses of the parliament successfully with required majority, the bill received assent of the Honorable President Srimati Draupadi Murmu Madam on 25th December 23 and got published. Now it is the well-known fact that these all three acts, the date of execution is the 1st July 24. Now what is the main amendments those are carried out in Bharatiya Nyay Sanhita 2023? In brief, of course the experts are here, they are going to focus on all these acts. In Bharatiya Nyay Sanhita, the new chapter 5 of offences against women and child has been introduced. Chapter 4 of abatement, criminal conspiracy and attempt, that is also introduced. Definition of child, this is very important, it is introduced. Definition of gender includes transgender. Electronic and digital records are included in the definition of document. This is also very important change which has been carried out. For the first time, community service as one of the punishment for petty offences has been provided. This is also very welcoming approach. New offences of Terrorist Act has been added. The offences as organized crime also has been added. Petty organized crimes, snatching, abatement of offences outside India, act endangering the sovereignty, integrity and unity has been added, and many other has been added. And very important change which has been carried out under this act is colonial remains like the British calendar, Queen, British India, Justice of Peace have been deleted. The Court of Justice has been replaced with the word court and the term denotes has been replaced with means. Therefore, 20 new offences has been added in Bharatiya Nyay Sanhita. 19 provisions that existed in Indian Penal Code 1860 have been omitted. In 33 offences, punishment of imprisonment has been enhanced. In 23 offences, the mandatory minimum punishment has been introduced. Community service has been introduced as additional punishment for few offences. Fines and punishments for various offences have also been suitably enhanced. So these are the changes which are made. Where in very brief I told you about the Bharatiya Nyay Sanhita. Similarly, in Bharatiya Sakshyam Adhiniyam, we find that electronic records are included in the definition of document. Statement received electronically are included in definition of evidence. Established electronic and digital records as evidence have been having the same legal effect, validity and enforceability as any other document. Expanded scope for the secondary evidence and comprehensive certificate for submitting electronic evidence added in the schedule. Similarly, references to colonial terminology, they are removed from this act. If we see this Bharatiya Nagarik Suraksha Sanhita, which in this sir is going to focus on, I'll just point out only 5 to 6 points. The Act seeks to provide a simple, consistent, transparent and accountable procedures, fair, time-bound, evidence-based speedy trials, reduced burden on courts and prisons, have increased the conviction ratio, strengthening prosecution on basis of forensic science in the investigation. I think this is the point of discussion. And uniformity in judicial justice system. Also, the Act aims to transform our judicial system to be an ultra-modern judicial system in the world. In the word of Honorable Minister Shri Amit Shah, the spirit of our constitution is of doing justice to all, and the Indian concept is founded on the award of punishment and dispensation of the justice. So friends, today we are going to have a detailed discussion on all these three acts. We are very fortunate to have with us Honorable Shri Sandeep Shinde sir, former Judge, High Court Bombay for the first session, Advocate Dr. Sujay Kantawala for second session on Bharatiya Nyay Sanhita, and Senior Advocate Dr. Mr. Rajiv Patil sir, who is going to join for the third session on Bharatiya Adhiniyam. I hope you all will enjoy this academic feast along with other hospitalities. I, from bottom of my heart, welcome you all in this inaugural session. Once again, I appreciate your presence. I think we have made the century for the registrations. So I appreciate the efforts taken by CTC as well as the GLC team for the same. I welcome you all again. Thank you very much.
CA Vijay Bhatt, and he is a stalwart and he will shed some light on the activities of the CTC.
Shinde sir, Honorable Senior Advocate Kantawala sir, Principal Madam Mrs. Vaidya, Advocate Mr. Valve, Chairperson of the Student Committee Niyati, who has been a strong pillar of organizing this event, our immediate past President Harish Kenya, members of various colleges, representatives, that is professors and teachers, that's what we learned, that all of you have come today, and our team from Chamber of Tax Consultants, organizing team of GLC, everyone, warm welcome to everyone here today on this fine educative morning for learning of new criminal laws. Criminal law itself, when we hear these words, you know, we come under pressure. So I'll make some light moments for all of you. Just to deviate slightly, please raise your hands who are the past students or present students of Government Law College. How many of you? Great. So do we have, I'm also from Government Law College, 91 batch. And incidentally, we all three, I mean, we were talking, we are all from 91 batch. So that's a coincidence, and world is very small. And at the same time, you know, 91 में हमने किसने सोचा था कि एक दिन हम लोग यहाँ डायस पे बैठेंगे. Yes, we used to sit on the various programs here. There were, you remember, this auditorium was without AC, and the charm itself was great. You know, students standing out on their balconies and all. So it's a wonderful event. So today I'm just thrilled that I'm representing not only the Chamber of Tax Consultants, I'm also a student of Government Law College coming back to my college days. So very humbly I'm presenting the Chamber of Tax Consultant, and just to brief you about the activities of the Chamber of Tax Consultant. The Chamber of Tax Consultant is primarily the educational association on no profit no loss basis, consisting of various members in the field of chartered accountancy, lawyers, company secretaries and other income tax practitioners. We deal into various tax laws, whether it is direct tax, indirect tax, international tax laws and so on. We have our various committees through which we organize our workshops on various educational activities, we have our direct tax committee, indirect tax committee, students committee, international tax committee, membership and public relations committee and so on. Our website is ctconline.org. You may visit it. Our association was formed way back in 1926, and 1 year later we'll be celebrating our centenary year. So I urge, we came to know that there are various members also of this our organization today present over here, and there are many non-members also. Our membership is open to even advocates and chartered accountants. We have student membership, so those who are not member, I would urge to them to take membership of our Chamber of Tax Consultants, because we are having so many activities coming up in the forthcoming year. In fact, next week we are having two big events. One was announced by Mrs. Vaidya. Niyati will also throw light on those events. And plus we are going to have budget meeting, we are going to have a workshop on the indirect tax, that is GST and all. So request you all to become member of the chamber, take benefit of the chamber, and in turn you also give your benefit of your academics to the Chamber of Tax Consultant. About these laws, you know, as Madam also mentioned, we all know these laws came into effect from 1st July 2024. So Chamber of Tax Consultant immediately took up this opportunity, and we found none other better organization than the Government Law College to have this absolutely fine on this auspicious day to throw light on this three laws. So I wish everyone a happy learning. I will not take much of the time between you and our learned speakers. Over to the speakers, and happy learning to all of you on behalf of the Chamber of Tax Consultants. Jai Hind.
It is my great pleasure to welcome all of you once again to this highly anticipated workshop on the new criminal laws organized by the Government Law College and Chamber of Tax Consultants. We are honored to have among us esteemed dignitaries, esteemed professors, distinguished advocates, experienced chartered accountants and enthusiastic students. As you all know, the new criminal laws, including the Bharatiya Nyay Sanhita, Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshyam Adhiniyam, have become effective from 1st July 2024. These laws mark a significant shift in our legal landscape, aiming to enhance justice delivery and ensure the protection of citizens' rights. Today's workshop is dedicated to understanding these changes, their implications and the practical applications of these laws. Our primary objective in holding this workshop was to provide a comprehensive overview of the new criminal laws. We aim to educate and inform all our attendees on these new laws so everyone has a clear understanding of them and how they differ from the previous laws. We wanted to create a platform for engaging discussions where legal professionals and students can share their insights and perspectives, and also focus on the practical aspects of these laws and their impact on our day-to-day legal practices. Friends, allow me to take a moment to share some of the activities and initiatives of the student committee of the chamber. Over the past years, we have organized numerous events and programs aimed at enhancing the knowledge and skills of our members. We organize a lot of webinars, seminars, workshops, long duration courses. I'll be also announcing on the income tax course in just a moment. Other than that, we also organize Udan episodes. They are inspirational sessions with eminent personalities from various professions who share their journey and success stories to motivate students and professionals alike. We organize a lot of competitions like the debate competition, essay competition, moot court competitions. Just the last year we had the inaugural edition of the GST moot court with the ILS Law College. On the income tax moot court, we've been organizing with Government Law College in past 7 years. And we are truly grateful to Principal Madam for her support. Now I'll announce on the income tax certificate course. So I'm very excited to announce that we are launching this course titled Practical Income Tax and Litigation. This course is going to begin from 2nd of August 2024, and it is designed to provide comprehensive knowledge and practical insights into the income tax and litigation. The sessions will be conducted by seasoned tax professionals, ensuring that participants receive high quality education and training. Registrations are now open, and we encourage all students to enroll and take advantage of this excellent learning opportunity. I would also like to announce that the inauguration ceremony of the course will be organized on 2nd of August in this college in the auditorium. It will be in the evening at 5 p.m. We are going to have Hon'ble Mr. Justice Abhay Ahuja as the chief guest. There will be a panel discussion where we will have the privilege of having Dr. Keshav Ram, senior advocate, CA Jayan Gokhale and many others for the same. So I invite everyone to be present for the same. There will also be a session on the basic concepts of income tax on that day, which is open for all to attend. I would also like to take this opportunity to invite all of you to subscribe to our social media handles, stay updated with our latest events, initiatives and educational content. For students, I strongly encourage you to become student members of the Chamber. Membership offers numerous benefits including access to exclusive events, resources and networking opportunities with professionals. To our esteemed professionals and professors present here, please you all also consider becoming a member of the Chamber and also encourage your students to enroll as student members of CTC. In conclusion, I would like to express my gratitude to all the everyone present here and our esteemed dignitaries, speakers and participants for your enthusiasm and commitment to this workshop. Let us make the most of this opportunity to learn, engage and grow together. Thank you and I wish you all a fruitful and enlightening session ahead. Over to you, Ananya.
Thank you, Advocate Nyay, for always displaying exemplary leadership. Now I would like to invite Advocate Shyam Walve to introduce our first speaker. And Advocate Shyam Walve is a practicing Bombay High Court advocate, and he has been instrumental in getting the speakers together. So,
thank you. Good morning, everyone. The dignitaries on dais, Justice Shinde, Dr. Kantawala, Mr. Bhatt, Mrs. Vaidya, and Mrs. Mankad, Niyati. Everybody calls her Niyati, but I am Mrs. Mankad. I have been given the task to introduce Justice Shinde today. The task would be difficult because there are so many things which I would like to share, but due to the timelines, the same has been kept in place. I have met Mr. Shinde firstly, Justice Shinde. I was introduced by one of my very good friend, Mr. Sachin Gurwadkar, who practices in Nasik. And I had the opportunity to work with him in several matters when he was practicing then. It was since, I believe, 2012-13, sir. And at that time, sir was one of the busiest counsel in the Bombay High Court. He not only had expertise in criminal law, but equally in civil laws as well. So he was always one of the choice for litigation. And as far as I belong to the Nasik bar, I am from Nasik. So the Nasik bar used to love him. He was the first choice to engage in any matters. He used to be approached. So at one point of time in every matter from Nasik, Justice Shinde used to appear from one side and somebody else from other side. That was the scenario. So I'll just briefly introduce Sir. Sir started practicing in the year 1992 in trial courts. Then he shifted to High Court and joined the chambers of Mr. Ashok Mundargi, senior advocate, who is also a renowned criminal practitioner. Then Sir appeared in number of civil, criminal, labor, service and constitutional matter. Sir then subsequently selected as a direct district judge. Served as a district judge in Amravati, Malegaon, Nashik, Alibag, Thane, Mumbai City Civil Court, and also served as a Secretary, Law and Judiciary, State of Maharashtra. On the issue of seniority, Sir resigned and Sir left and Sir resumed practice again. Thereafter, Sir has appeared for the State of Maharashtra as a Chief Public Prosecutor and Government Leader in several criminal matters. Sir was also standing counsel for CBI, Enforcement Directorate, Bank Fraud Cell Corporations, and High Court Administration till his elevation to the bench. During his days of practice, Sir was also appointed as amicus curiae in several matters by the Honorable High Court. Sir again answered the higher calling and accepted judgeship of the High Court at Bombay. He had sitting at Aurangabad, Nagpur and Goa benches, and Sir superannuated in year 2023. Sir was designated as a senior advocate by the Honorable Supreme Court. As on today, Sir is practicing as an arbitrator and a senior advocate appearing in Supreme Court. Presently, Sir is also advisor to the state of Maharashtra in reservation matters. As an advocate, Sir was very humble and soft-spoken, also as a judge and again as an advocate. I am grateful that Sir, out of his extremely busy schedule, made himself available for this workshop. Now I will hand over to Honorable Justice Shinde with a request to address the gathering on the topic of Bharatiya. I'll hand it over to Ananya. So.
Dr. Vaidya to felicitate Justice Shinde, and thank you, Shyam, for wonderfully introducing Justice Shinde, and participants, you are very, very fortunate to have him today. Who is our Vice Chairperson, to introduce our second speaker, Dr. Sujay Kantawala.
Thank you, Ananya. Good morning, everyone. It's my distinct honor and privilege to stand before you to introduce our legal luminary and a prolific author and a dedicated environmentalist, Dr. Sujay Kantawala, born on 7th April 67 in a family of lawyers in Mumbai. His journey in legal realm began with St. Xavier's High School, Dhobitala, and continued through St. Xavier's College and Government Law College, Mumbai. Since his enrollment in 1991, he has built a remarkable career in practicing before Honorable Supreme Court of India, numerous high courts across the country, and various tribunals. His expertise span a wide range of legal fields, including constitution and administration law, indirect taxation, customs, central excise, service tax, and more. He has over 400 reported judgments to his credit, published in esteemed law journals such as SEC, AIR, and ELT. His contributions are not confined to courtroom. He has served as amicus curiae in landmark cases, including the famous Urta Punjab movie case and significant PILs addressing social and environmental issues. His dedication to pro bono work is exemplary and have appeared in cases that have made substantial impact on public welfare. Beyond his legal acumen, he is a celebrated author with 3 poetic books and 3 novels that have resonated with thousands of readers. His environmental contributions are equally commendable, maintaining over 2,000 trees in his farmhouse area at Boisa. His academic excellence is reflected in his teaching skill, where he stood first class first in Government Law College and was appointed fellow. He has also been an influential voice in media, participating in over 1,000 TV debates across multiple languages. He is multifaceted, contributed to law, literature, society, and make his remarkable individual whose insight and experience we are fortunate to hear today. So please join me in welcoming Dr. Sujay Kantawala to GS. Welcome.
Thank you, Chami, for introducing Dr. Sujay Kantawala. Session. I would like to request you to make the most of it and such opportunities are actually very rare. And now I would like everybody to stand up for the national anthem, please.
Good morning, everybody. Dr. Asmita Vaidya, Dr. Sujay Kantawala, Advocate, Bombay High Court, Shri Vijay Bhatt, President, Chamber of Tax Consultant, Advocate Shyam Badve, Advocate practicing in the High Court, Advocate Ashok Kotangali, Advocate Nyay, the chairperson of the Students Committee, all dignitaries, professors, law students, and advocates. I have been introduced as an expert on the criminal law, but I differ with Advocate Valve for several reasons. The first reason would be that as you go on reading the law, you understand that you missed many concepts in past. Nevertheless, when I was told that you will be invited to deliver the lecture on the new enactment, I chose the Bharatiya Nagarik Suraksha Sanhita, which in the course of today's session I would refer to as a Sanhita instead of always calling it as a Bharatiya Nagarik Suraksha Sanhita. I came across, I revised the old CRPC, tried to compare with the new provisions of the Sanhita. Of course, what I am going to say today would be my own personal views on the interpretation of the provisions of the law. First and the foremost thing I must tell you, the changes which have been brought in no manner or in no way changes the jurisprudence. It doesn't changes the form or the core concept of the criminal procedure vis-a-vis the powers of the magistrate and the criminal courts. Rather, we are concerned with the supervisory powers, because a magistrate not only discharges or enjoys the jurisdiction or the judicial orders he passes, but he also has a supervisory jurisdiction to some extent. Now, supervisory jurisdiction in the Criminal Procedure Code, you all are aware of it, that it starts with the investigation and culminates into the trial or the sentence, and then of course the appeals and further proceedings. So it's divided into the executive powers and the judicial powers. The separation of the power is in a core of our constitution, and nobody should encroach over the jurisdiction of the executives. But nevertheless, while administering the justice or while dispensation of the justice, though there may not be a complete control, but we call it as a supervisory jurisdiction of the magistrate over the functioning of the working of the investigating officer. For example, how the supervisory jurisdiction. Under the old law, even under the new enactment, whenever there is an FIR is lodged, a copy is required to be sent to the court. In several provisions, right from 154 to 173 until the charge sheet is filed, I will be referring to this section and to the CRPC because I am not much conversant with the present sections of the Sanhita. In other words, I would say once there is an lodgement of the FIR and when the investigation starts, at every stage you will find there has to be an intimation by the investigating officer as to what he has done or what is he going to do to the jurisdictional magistrate. I use the word a jurisdictional magistrate, reason being under the new act, the word jurisdictional magistrate is missing, but the more emphasis is laid on the nearest magistrate. I fail to understand as to why it is being done. Nevertheless, when we will go to the relevant provisions, I will elaborate this issue. So we were on the point that the magistrate also enjoys or has a supervisory jurisdiction. He supervises whether the investigation is being done in the fair manner or not. I use the word fair because unless there is a fair investigation, there cannot be a fair trial. So the basic foundation of the criminal jurisprudence is that there has to be a fair investigation. The concept of the fair investigation is not vis-a-vis applicable only to the victims but to the accused also. So our procedure has to be a balancing the rights of the accused and the rights of the society. That is what our jurisprudence and Article 21 says so, and effect has been given thereto in the CRPC. It would be interesting to note that though our constitution came to be enacted or came into the force, even before that there was a CRPC. And it would be also interesting to note the old CRPC also takes care of the fair investigation and the fair chances to the accused. Almost all provisions of the CRPC are to be interpreted in view of the Article 21. As I said that the changes which are brought in the Sanhita does not change the core or the basic edifice or the jurisprudence or the criminal jurisprudence at all, neither it curtails the powers of the magistrate. The magistrate enjoys or has still the supervisory jurisdiction over the functioning of the investigating officer or the executive powers. What changes have been brought under the CRPC is to achieve there has to be an early disposal of the litigation, early disposal of the cases, to make it more efficient and to flow with the time. The legislator rightly thought that investigation cannot be in the traditional way, conventional way. Something more is required to be introduced so that there would be an effective dispensation of the justice, and therefore the electronic evidence has been introduced at the several stages. The means of communication, the recording statements of the witnesses or the victims have been brought, and those changes we must welcome. There are a time-bound schedule or in the many sections when there is a compliances are to be done. The Sanhita has said you have to do it within a particular period. And therefore I think that will bring some changes, not a complete change in the system itself. The another aspect I would we looking into the Sanhita is this, that it is somewhat victim-centric, or some rights, or we have acknowledged the victim's participatory rights in the trial. Until the victim has been, the concept of victim was introduced or brought in the CRPC, the victim was sitting on the fence. Plus she had no right, she had no participatory rights in the system at all. Everything was as against the accused and accused-centric. Victim was kept away completely from this system. But now, since last 10 years, I don't know date on which the victim concept was brought into the statute. But now the Sanhita has acknowledged the participatory rights of the victim at every stage. Now, for example, if the victim may not be an informant, but victim of the sexual assault, then she has been given several rights. One of the rights I must appreciate is that earlier the withdrawal of the prosecution was completely left to the discretion of the public prosecutor or the additional public prosecutor. Of course, he was required to see the case objectively and present before the court while withdrawing the prosecution. And obviously the court has to look at whether the case has been made out for the withdrawal of the prosecution or not. But at that time, under the old provisions of CRPC, the informant had no right to be heard. But now they introduced a concept that before a withdrawal of any prosecution, the informant is required to be heard. So a concept of the inclusiveness is sought to be brought on the statutes, and we must welcome this change. So there are, so far as the victims are concerned, there are several provisions are being brought in the statutes or in the Sanhita, and her rights are acknowledged. For example, now we all know that in case of the sexual offences, particularly some of the sections or some of the offences like a gang rape and others, there is a statutory right that before granting the bail, she is required to be heard. Earlier this provision was not there. The CRPC retains that provision, and the new CRPC introduced that provision, and maybe probably after Nirbhaya's case. And the Sanhita acknowledges her rights to be heard before granting the bail to the accused. Likewise, we will find that in the old CRPC as well as in the Sanhita, the witness protection has been extended. Some changes have been brought. That is one of the welcome changes. So what the Sanhita is focusing is that to the quick trials, to collect the evidence, technical evidence through the experts, place it before the court, and some watertight compartment so far as the discharge of the executive powers are concerned is sought to be achieved. So we must welcome the change, but at the same time we must also look into the certain provisions of the Sanhita as to whether those are the fair to the victim, the fair to the system, and the fair to the accused or not. The first change I would like to, the first section which I would like to read out is so far as the section 167, equivalent to now under the 187 of the Sanhita. I have my own reservations on these provisions. Before commenting, I would like to read the certain provisions of the 187, and before that I must just give you the outline what the scheme of the CRPC was and what the scheme brought on the statutes by the Sanhita. We understand that when the accused is arrested and he has to be produced before the magistrate within the 24 hours. So detention beyond the 24 hours was required to be authorized. Of course, the genesis would find 22, I believe, or 22 of the Constitution. And following that mandate of the Constitution, the provisions were being enacted under the CRPC as well as under the Act, Sanhita, saying that if the police officer wants to detain a person beyond 24 hours, it has to be under the authority of the law, and therefore he is required to be produced before the magistrate. The word used even in the Constitution is the nearest magistrate. Maybe for the reason on the given date or given time, the jurisdictional magistrate may not be present or available, and that would create some hurdles. So rightly the Constitution has been followed, saying that 187, under the Sanhita 187 section, they said when the person is brought, arrested, he has to be produced before the nearest magistrate within 24 hours. And once he is produced before him, it is the magistrate who will decide where he is to be remanded, whether to the police custody or to the judicial custody. So there were options given to the magistrate. Now the old law says that a person cannot be remanded to the magistral custody in whole for 15 days. Sorry, to the police custody in whole for the 15 days. Though the 167(2) does not say, or it only employs the expression such custody, the expression such custody has been clarified in the first proviso to the 167(2), which says that the person could not have been remanded to the police custody for more than 15 days or whole. Under the new enactment, that is the Sanhita, that has been not explicitly stated. The expression such custody which has been used under the Sanhita has not been clarified, which was earlier clarified by the way of the first proviso there. So there remains some sort of an ambiguity in the mind of the lawyers, litigants, and maybe the magistrates also. To put it simply, whether a person when arrested under the new law says that he could be remanded to the police custody in segments, not within the first 15 days of his arrest, but it could spill over the 40 days and the 60 days of a default period. So the legislators were intending, or could be in the given circumstances, or in some cases, as we see that in many high profile cases, when the person is suspect is arrested, he would prefer to get admitted in the hospital. Central Balaji is the recent case in 2023. A MP or the elected representative from either Kerala or Tamil Nadu was arrested, and the next moment he was admitted in the hospital. So taking into consideration that if the person or the suspect gets admitted in the hospital, what would be the period during which he could be investigated? Because earlier law, in the case of Anupam Kulkarni, decided in Bombay High Court and of course by the Supreme Court, saying that the period of the 15 days under the 167(2) read with the first proviso, meaning thereby it is the first 15 days. The concept of the first was a judicial interpretation, saying that if you are not able to interrogate him within first 15 days in the police custody, you may not be in a position to interrogate him. And then obviously he would go into the judicial custody. This has no doubt adversely impacted or may be impacting the effective investigation, because as the time passes, there are every chances of the evidence to lapse or may not be available. And that's the whole holistic purpose or the whole philosophy was that when the crimes take place and when the accused is arrested, he is required to be detained for the two purposes: that he would not see that the evidence is taken away, and he would not influence the witnesses. That was the whole purpose. But this purpose has been circumvented by many suspects by getting admitted into the hospital. So he is not available for the interrogation. There won't be further clues to the investigating officer to further the investigation. And therefore there could not be an investigation said to be effective. And when there is no effective investigation, as I said earlier, unless there is an effective investigation, there cannot be a fair trial. And if there is no fair trial, it's going to be a result into the acquittal. That could be one of the reasons why there is an acquittal rate is more. So everything was found, the legislator found, the record found, and the history says that because of the not proper investigation, there is the low rate of the conviction. Now, how to curtail it, how to stop it? Because if he gets admitted immediately into the hospital, then the investigation is not possible. Therefore, the new legislation said he could be investigated at any time over first 40 days or the 60 days. Depends on the crime, nature of the crime, or during the default period. That appears to be the whole purpose, and that is what in the case of the sentence Balaji also they have expressed it. But still myself is also confused. Of course, anybody can set right me if I am wrong in interpreting the subsection 2 of the 187. Unless there is a clarification to the extent by the legislators that the 15 days whole period, even it can be segregated or it is spill over the 40 or 60 days, it is required to be clarified that the police custody will not exceed the 15 days. That clarification is not coming forth, at least to my knowledge. And to understand this concept, let us see the 187. What may happen is this: there will be the two repercussions of this I could see. The executives in the selective cases may interpret the subsection 2 to mean that such custody is not limited to the 15 days. I mean to such custody means the police custody may not be limited to 15 days. And it could be over any days, 40 days or the 60 days. Depends on the gravity of the case or the offense which has been registered. I said in the selective cases it may be possible. The second aspect I would see, that is on a practical point of view. For example, on the 10th of July, a person is arrested, where the default period is the 60 days. So 40 days, let us say 40 days. The police in the first remand seek his police custody, and the magistrate grants him custody for 5 days. So he would be in the police custody till the 15th of July. Automatically, he would be from the 16th, he would be in the magisterial custody or the judicial custody. He would make an application for bail. Take for an example, it's an offense under 379. If he is granted bail after hearing the prosecution and the accused, he is released on the bail on the 20th. In this case, the default period is of 40 days, so the 40 days would get over on the 10th of August. On the 5th of August, the investigating officer comes across a evidence, some clinching evidence in a given offence. He would go to the magistrate and request for his police custody. Because he has only completed the 5 days, 10 days were at the command of the investigating officer. So during these 40 days, he could be taken into the police custody at any time. Question is this: once he has been released on the bail, then how this position could be reversed unless his bail is cancelled. So bail has to be cancelled for the reasons to be stated or according to the provisions of the Act itself. It would be really a practical difficulty for the investigators or investigating officer in the selective cases may invoke these powers. How these provisions could be said to be fair to the accused? There will be the hanging sword throughout the 40 days or the 60 days. He would not know when I would be taken into the police custody. It could be on the last 39th day or on the 59th day, as the case may be. So what is the guarantee? What is the sanctity? And what is the purpose of it? Are we really going to achieve the purpose by spanning over this period, over the 40 or the 60 days of the default period, as the case may be? And what is the practical way out if the police officer wants his custody on the 35th day or the 55th day? How is he going to substantiate it? Even if he goes to the court, in the present case, on the 5th of, as a case I have quoted, hypothetical, on the 5th of August, he has to satisfy the court as to why and what reasons he wants the custody on that day. I think it would be very difficult, because seeking the custody of accused on the 35th day from the date of his offence, it would be a futile exercise, because by the time when he was on the bail, on the judicial custody, the accused was always in an endeavour to see that or influence the witnesses or see that evidence is not made available. So what the investigating officer would achieve? What is the purpose behind it? So would it be fair to look into these provisions so far as qua the accused and his rights of the accused? If you take my personal view, it's my personal view completely, if they wanted to overcome this situation, and in the Senthil Balaji, they have also accepted the case. No, in the Senthil Balaji, they said the 15 days means 15 days the police custody. Only change that has been brought is the word prior. The first 15 days has been taken away, and that has been spread over the 40 days or the 60 days. But according to me, in my personal view, it may not achieve the purpose or may not result into the effective investigation as sought to be the purpose for bringing the statutes in the Sanhita. What they could have done is that if an accused or the suspect gets admitted into the hospital, soon after the FIR is registered and is arrested, in such cases, his period in the hospital is to be excluded from the first 15 days. This was one of the ways by which they could have curtailed this practice of getting admitted into the hospital. Of course, there could be some other ways which are not within my knowledge or I am not able to comprehend. But looking into the judgment of the Balaji Senthil, where the MP from that Kerala or Madras got admitted and it was hampered, the investigation could not be a proper investigation. And of course, the bench did not agree with the judgment of the Anupam Kulkarni and also of the constitutional bench judgment delivered by the 3 judges I don't know why that 3 judges bench judgment was not binding, because that was by the two judge bench, the Senthil Balaji, which referred the issue to the larger bench. Nevertheless, that is not a topic to be discussed today, and more or less now the reference become academic and infructuous, because there are the changes in the Sanhita itself. So emphasis is this purpose, object. Was there any transparency in the object of it? And what was the object? I could not lay my hands on the report of Dr. Singh, who was the Vice Chancellor of Delhi University, who was the chairman of the committee who has been appointed. I could not get the report itself as to what was the purpose enacting this 167.2 and removing, 187 and removing the 167.2. What was the purpose? I did not understand it. The second object is this. Second objection is this. In everywhere you will find the production of the accused for the first time is made to the nearest magistrate. Now if you see the criminal courts classification, the criminal courts include the magistrates, metropolitan magistrate has been taken away, session judge and the 2 higher courts and executive magistrate. The executive magistrates is one of the criminal courts, was under the CRPC and under the Sanhita. Now executive magistrate on which the judicial powers are conferred would be or maybe a nearest magistrate under the 187.2, where the accused could be produced seeking the remand. It is not only limited to the first remand, it's very interesting. If he is produced before the nearest magistrate and not a jurisdictional magistrate, I mean to say, jurisdictional magistrate means the magistrate who has the power to conduct the trial or make an inquiry, will have a jurisdictional magistrate. Apart from that, 187.2 speaks solely about the magistrate or the nearest magistrate, which may include the executive magistrate. Now, executive magistrates are none less than the executives or the SDM, the special, the collectors and the SDOs or the SDM we called, on whom the powers are conferred. So they are not a judicial magistrate. So possibility of misusing in the selective cases in such matters, taking reports to the 167, cannot be ruled out. And there is no plausible explanation or a rationale as to why even in the second remand the powers are given to the nearest magistrate and not to the jurisdictional magistrate. So looking into the whole theme or the concept of remand under 167, it raises some reasonable doubt as to purpose and the reason behind it, giving go by to the well-founded, accepted for the long period, acknowledged by the judicial pronouncements. It would be the first 15 days which could be amended, which the legislature could have achieved a purpose by appending some explanation thereto, or curtailing the period of the 15 days when the suspect is admitted into the hospital. This was the easiest way, but for the reasons I could not comprehend. Mr. Kantawala may, because he practices also in the trial court, may be able to throw lights on this. So to understand this, I would be taking you to some provisions of the 187 and the purpose, as I said. See, the 187, it reads subsection 2 only. I will read because that carries some importance. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction, So he may not be a jurisdictional magistrate. Whether he has or has no jurisdiction to try the case, after taking into consideration the detention of the accused in such custody, after taking into consideration, authorize from time to time the detention of accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in a whole or in parts at any time during the initial 40 days or 60 days out of a detention period of the 60 days or 90 days as the case may be, as provided under subsection 3, and if he has no jurisdiction to try the case or commit it for the trial and considers further detention unnecessary, he may order the accused to be forwarded to the magistrate having such jurisdiction. And now I will also read the subsection 4. No magistrate shall authorize the detention of the accused in a custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in the custody of the police, but the magistrate may extend a further detention in the judicial custody on production the accused either in a person or through the audiovisual electronics. So it contemplates that he has to be produced for the first time in person and thereafter he could be remanded on the electronic means. There is one more section which I am not able to understand, or I could not understand rather, saying that they have defined what is when he is in a police custody where he has to be detained, and when he is in the judicial custody where he has to be detained. I am not able to find the exact provision, but as I understand that when he is remanded to the police custody, he has to be retained in the police station. So necessarily when he is remanded to the police custody for 5 days, what the law contemplates, he has to be only in the police station. Whereas when in the judicial custody, he has to be in the jail which is notified by the state government. Now for example, in the given case, if there is a discovery and the accused is required to be taken to the another state or to another place, then it can be very well argued that he was not kept into the police station or a local police station, because now they have defined the accused is to be remanded to the, when remanded to the police custody necessarily means in the police custody, in the police station. So how this, what would be the reason? What could be the reason? Of course, the law says when he is in the police custody and even if taken outside the police station, he would always remain in the police custody. Why this clarification has been added and giving some more clues to the accused to argue for number of remedies? When the law is already settled on this position, he continues to be in the police custody. He need not be confined within the four corners or the four walls of the jail or the police station. So these provisions I always, it's a jumbling provision. I don't know how many of you are frequently appearing in the trial courts and whether any of you has encountered this situation. So far, of course, it would not be. But I am not aware as to what practice is being now followed in the magistrate court and whether there is any such instance that after releasing the accused on the bail or remanding him to the judicial custody, the police officer has applied for transfer of custody, that he may be again taken up into the police custody and what procedure has been followed. So this is the one concern I am concerned with the provisions. Now the second provision which also bothers, of course again I said it is it's personal view, that powers given to a magistrate to attach the property. Earlier it was 102, I believe, CRPC 102. And in the 102, the police had powers to seize the property of the accused, suspected, or if it is a suspect that these powers or this property is in a proceeds of crime. It's not exactly what proceeds of crime use. And obviously 102 was always exercised. If the police found the money lying in the bank account was an amount defrauded or the defrauded sum, for the purposes of the investigation, the police has the powers to seize the property, that is the bank account. It was an old case of a tapas niyogi which elaborated the powers of 102 of the CRPC. The question in one of the cases before the Supreme Court, whether the magistrate will have the powers to attach the immovable property of the accused or of a suspect, even if it is found it is a purchased or outcome of the proceeds of crime. A series of judgment, and the last judgment that was somewhere in, I do not recollect, but 2019, that is Nevada's case. But the Supreme Court candidly or clearly said such property or any property, it's not a such property, any property does not include the immovable property. But Supreme Court has clarified, suppose a property is found to be acquired from the proceeds of crime, then the police cannot attach it. The magistrate cannot attach it. But the title papers of the land, being a movable property, it could be attached. So the purpose was served there by keeping this window open by the learned judges of the Supreme Court, saying that you can attach this because that is a movable property. I don't know why. But this new Sanhita 107 says that, or indicates or suggests the magistrate's powers to attach any property without clarification. It's limited to the movable property. Again, it is opening the window for the litigation. Just to understand this provision, I will read 107 of the new Sanhita as to how it has been worded and the manner in which and what the magistrate is supposed to do in case if it is found that certain property has been purchased out of the sale proceeds. Attachment, forfeiture or restoration of property. See, the attachment, forfeiture or restoration of property. Where a police officer making an investigation has reason to believe that any property, try to understand, any property is derived or obtained directly or indirectly as a result of the criminal activity or from commission of any offence, he may, with the approval of the superintendent of police or commissioner of police, make an application to the court or the magistrate exercising the jurisdiction to take the cognizance of the offence or commit for a trial or try the case for the attachment of such one. Then what the magistrate would do? If the court or the magistrate has reason to believe, whether before or after taking evidence that all or any such properties are proceeds of crime, the court or the magistrate may issue notice upon such person, calling upon him to show cause within the period of 14 days as to why an order of the attachment shall not be made. Now stopping for a moment. Application has to be made with the permission of the superintendent of police if it is found this property has been proceeds of the crime. Good enough. He makes an application to the magistrate. Now the magistrate would issue notice upon such persons means whom? Such persons means who? The owner, assignee, the person who has created the charge over the property. If the property is mortgaged to the bank, to whom? Possibility cannot be ruled out. There could not have been a charge on the property visible from the revenue records or the 712 extract. But possibility that the property might have been mortgaged with the bank, and the bank is having the charge over the property, and later it is discovered that this property was purchased or out of the criminal activity or the proceeds of crime. Therefore, even if the magistrate issues the notice to the person who has committed the crime or the suspect or the accused, then the persons who are having the beneficial interest or the enforceable rights in the property are being kept away, and the property would stand attached and forfeited. So what is the justification when there is no clarification in the rule itself? Because it says that the court or the magistrate may issue a notice upon such person. Upon such persons means a person who is the suspect or the person who has committed an offense. So the real owners are being kept away. Now third, subsection 3, where a notice issued to any person. Now any persons means what? In subsection 2 it has been used such persons. Necessarily I can link it to the accused or the suspect from whose property was purchased. Ostensible owner, he could be an ostensible owner whose names has been only reflecting in the revenue record, but really property he could have given mortgage to somebody else or transferred it or gifted away. To such person, subsection 2 specifies any property being held by any other person on behalf of such person. A copy of notice also shall be served upon some other person. The court or the magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material facts available before such court or the magistrate, and after giving the reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be proceeds of crime, provided that if such person does not appear before the court or the magistrate or represents his case before the court or the magistrate within the period of the 14 days specified in the show cause notice, the court or the magistrate may proceed to pass ex parte order. Notwithstanding anything contained in subsection 2, if the court or the magistrate is of the opinion that issuance of notice under subsection 2 would defeat the object of attachment or a seizure, the court or a magistrate may by interim order pass ex parte direct the attachment and seizure, and so and so. 6. If the court or the magistrate finds the attached or the seized properties to be the proceeds of crime, the court or the magistrate shall by order direct the district magistrate to ratably distribute the such proceeds of crime to the person who are affected by such crime. So the whole scheme which was under the MPID, Mr. Kantawala would be in a better position to elaborate on this. We have the special enactment called the MPID Act. We find that many companies are inviting the deposits with some schemes, attractive schemes are offered, and people invest there. That was a big issue. Therefore, the state has enacted that, the Maharashtra, some MPID Act. There the courts are being provided, the special courts, powers conferred on the session judge, is provided with the infrastructure where the collector is one of the competent authority who has been given a powers. Being an executive authority, he will have all powers and incidental powers. Now take for an example in a case where the application is made to the magistrate for the attachment of the property of a company who allegedly had invited the deposits with the attractive rate of interest, failed to pay 420, 406, all cases, all offences are invoked. Application is made. What machinery is available with the magistrate to find out, and how is he going to implement it? That would be the second question, though time period is only 14 days. Do you believe that this could be possible within 14 days? The timeline which has been prescribed is a completely it's not a practical. It's not possible at all to specify the timeline of 14 days. Second aspect, if you read the provisions it would see the satisfaction of the magistrate that it is the proceeds of crime. Now to come to this conclusion, even the prima facie, there has to have some evidence before him. Now, is it possible for the magistrate merely on the making an application by the officer that this property is a product has been acquired from the proceeds of crime? And you expect the magistrate to record the satisfaction that this is the proceeds of crime, because that would be a revisable order. Could be revisable order, appealable order, because it is a judicial order. And it may affect in longer run in the trial also. And again it is being stated with or without evidence. So if he wants to take the evidence, he has to issue the summons. He has to examine him. If it is an evidence, he is to be cross-examined. Is it possible to complete this exercise within 14 days? So putting the timeline is attractive. But on the ground reality is completely different. And how the magistrate who is already burdened with the remand work in the afternoon, Mr. Vadave and Kantawala will be enabled. You all people know, if you rush to any metropolitan court at 2:30, you won't dare to enter into the courtroom because there is no space. He is attached to the 5 police stations. The remand is at least about the 30 or 32 cases a day. It's my own experience because I have worked at the taluka level as a judge. In the afternoon, we wish to have at least 4 to 5 police stations for remand, and there was no other judicial work he was able to do. Now, under these circumstances, what I want to hint is this: before enacting or giving these powers to the magistrate, is it going to really fructify? Is it going to give some results? And what about the parallel provisions which are available or the remedies available under the MPID Act? It doesn't say notwithstanding anything contained, or it will override the provisions of the MPID, because these are analogous to the provisions of the MPID, the attachment of the property given to the collector who would be the competent authority by issuing notification. Their properties could not be attached simpliciter because satisfaction is arrived by the magistrate. Under the MPID, whenever the property is suspected to be from the deposits or the proceeds of crime, first there is a notification in the Gazette. The objections are invited, and after considering the objections, the order of attachment is passed by the executives. And once those properties are attached, the properties are transferred to the court, designated court, and the court starts functioning as to distribution and everything. Here everything has been sought to be brought under the one roof, giving the magistrate all the powers of the civil court. So this would be, though there is an attractive to say that the timelines have been provided for expediting the trials and the proceedings, it would be really not going to work out. So this is another provision which I believe may not be practical for one more reason. Now, under the PIT NDPS Act or under the NDPS Act, when the property is acquired from the proceeds of the crime from the narcotic business, under the NDPS Act, you have the power to attach the properties. But there is a first competent authority. From there is appeal, and finally it goes to the tribunal. And once it goes to the tribunal, the process of confiscation to the state or forfeiture of the property goes to the state. Once the property is forfeited or confiscated, the title automatically passes to the state in whose favor it is forfeited. Where are those powers? So there are safeguards which were available. Safeguards were provided under the MPID Act or under the NDPS Act where the properties are attached. Such procedural safeguards is one of the requirements of Article 21, one of the requirements of the Constitution. There has to be a fairness, the procedure has to be a fair procedure. Is it a fair procedure to a person whose property has been attached? So there is a possibility of using these powers selectively. Again, I am using this word selectively. So try to understand as to really this is going to fructify or bring a good change. Though apparently we find that several timelines are provided, are they going to really help for expediting the process? I am not criticizing it. I welcome the changes, but these welcome changes are to be a balance or to be seen what was the ground reality and whether it is possible for us to adhere to these timelines and what are the consequences. Right to a fair trial, or we called at the earliest the case should be disposed of, though the constitutional mandates are there. Those constitutional rights, whether it is possible to enforce under CRPC unless you go to the constitutional court like a high court and request the high court, my case is pending since 2001, today I am 78-year-old, please expedite the trial. So meaning thereby, though timelines are provided, what are the consequences? What consequences are provided? Now under the timeline, I will just read out what are the timelines, and if the timelines are not strictly adhered to, the criminal CRPC does not provide any remedy for it. One timeline I must appreciate, that is a timeline that the lawyer cannot now seek more than 2 adjournments. It was under 309 earlier, but now the 346 subsection 2, the B proviso there too says that adjournment would not be more than 2, and if it is to be granted, only by recording the reasons. So this change I must welcome. We all must welcome, because several adjournments when I started the practice 1990 except under the CRPC, so that some evidence comes on the record, and that would be fair to the accused as well as to the victim. There was no time period. Now the time period which has been introduced is 90 days. It could be only for the 90 days, but still there is no clarification on this point. Why I am saying this? Now further investigation concept in the many laws, I mean the judgments of the Devrapalli or thereafter the judgment of the Amrut Bhai, the 2019 judgment, there wasn't a debate that whether or the old of the Abhinandan Jha, very old of 1964-65 case. Further investigation could be carried out till what period? At what point it ends? That was the issue, and that has been settled in 2019 by the Justice Rohinton, Nariman Rohinton. Earlier view was this, that charge sheet is filed, cognizance is taken, but trial has not commenced. These are the 3 stages. Submission of the charge sheet, magistrate takes the cognizance, and the trial commences, or the first day of the trial. So, earlier view was this, that once the charge sheet, once the cognizance is taken, but charge is not framed, there could not have been the further investigation. That was the view in the Devrapalli's case, which has been reversed, or saying that it does not preclude. So until the commencement of the trial commences on the date on which the charge is framed, the further investigation is possible. So the law is clear, law was clear when the Sanhita came onto the force. Now, in view of this settled law, I will give you the citation for your to understand this concept really. That is Vinubhai's Malaviya's case reported in 2019-17 SCC, where the timeline has been framed by in the judgment as to till what date further investigation is possible. So they said investigation is possible till the charge is framed and not thereafter. That is what my reading is. Now, if you read 193 subsection 9, that is equivalent to the 173.8. Now 193 subsection 9 makes the reading very interesting. Or reports regarding the such evidence in the form as the state government may by rules provide shall so far as may be applied with relation to such so and so so and so. Provided, now I am on the proviso. Provided that further investigation during the trial may be conducted with the permission of the available permission of the court trying the case, and the same shall be completed within the 90 days, which may be extended to the permission of the court. There is one confusion, ambiguity. First charge sheet, further charge sheet. Further charge sheet permissible as per the settled law till the charge is framed. So there could not have been the further investigation after the charge is framed. That is what the law was settled. Now wording is this: provisos are provided that further investigation during the trial. During the trial indicates or suggests a stage after commencement of it. So does it mean that the investigation will go on even after the commencement of the trial? Because further wording is important. Further, provided that the further investigation during the trial may be conducted with the permission of the court trying the offence. Against trying the offence is in a present continuous tense. So once the tense is a present continuous, neither the past perfect, meaning thereby, as I understand the plain reading is that even the further investigation pending trial or during the trial is perfect, because expression which is being used is a during against the present continuous tense, trying a present continuous tense, and proviso to the subsection 2, so carving out the exception to the main section. So till what period it will go on? What is the rationale? How are we going to achieve? Whether that gives a complete powers to the executives to withhold certain information while presenting the additional evidence, and then come before the court and say, look, we have received this information, please grant me the permission to file it for the charge sheet. What it would result into prolonging the case. So are we really serious about this timeline? Possibility of using these provisions in the selective cases to prolong the trial cannot be ruled out. So the timelines which are framed has to have some rationale. It's not only a cosmetic surgery that you will give it within 14 days, you will give within 7 days. What is the purpose? How are you going to achieve it? Now they say in case of the victim of the sexual offences, a report has to be submitted within 14 days. Good enough, it's in a good welcome stage. I must accept it. When I was on a dais in the many cases, there was no report under the POCSO of the victim for months together. But now we are putting the 14 days time. Do we have that machinery or infrastructure at the command of the court? We don't have. So how are we going to achieve this? Now, again, they have brought 193 to a timeline. Very interesting. Investigation in the POCSO cases on the sex-related offences to be completed within 2 months, that is 60 days. Welcome change, but there are no consequences provided. The only consequence under the POCSO, I understand, the court is empowered to direct some inquiry against the hearing officer, nothing more than that. Now there is a 194 section introduced called the accidental death report, that is an ADR, which was earlier under the 174 in case of the burn cases or in the suicide cases or in the accident cases, purely accident cases, purely suicide cases or the burn cases. The executive magistrate was required to submit the accidental death report, ADR we called, which is now stated to be provided in the 24 hours, which appears to be a difficult timeline, but we must welcome it. Only welcome one more, the timeline is that I said earlier that victims' participatory rights are acknowledged, and that is a really welcome change. Earlier she was on the fence, she was not doing anything, she did not know what was going on. But now there is a statutory right and obligation on the part of the officer that a progress of the investigation would be informed to her within 90 days and even by the electronic telecommunication. The same way the supply of copies of the charge sheet. Earlier the charge sheet copies were only available to the accused, but now even the informant or the victim both will have right to collect it. Now framing of the charge, they said that charge has to be framed within 60 days after hearing, on the first day of the hearing. Once both the prosecution and the accused are heard, the court is obliged to frame the charge within a time or period. Now 173 they have introduced, which was under 154. 154 speaks of the powers of the magistrate, police to register the office. There is one interesting fact here. They have introduced under 154. 154 says if there is any information disclosing the cognizable offence, the police has to register the offence. Simple. So offences which are classified cognizable, non-cognizable, if information discloses the cognizable offence is committed, you record it. Don't wait for anything else. That was the mandate of the law. And that mandate of law is no other than by the Supreme Court. No option. There was no option given to the police station. But under the 173, they say if the offence is punishable with more than 3 years, less than 7 years, option is given to the investigating officer to conduct a preliminary inquiry. Now this mandate, this provision completely runs the contrary to the well-known judgments of the Supreme Court. How are you going to meet with this situation? So this is something appears to be difficult, because Supreme Court in clear words says the officer, there was an argument to that extent. The satisfaction, the kind of satisfaction, what satisfaction he has to see or understand before recording the offence, Supreme Court said nothing. If it discloses the cognizable offence, you must register it. But giving go by to this, probably I don't know what is the object. It says the investigating officer under such circumstances in the offences punishable more than 3 years and 7 years can ascertain his satisfaction by the preliminary investigation. Wording is that to ascertain prima facie case exists or not. Now some offences which are punishable with the 7 years are obviously the cognizable offences. Now giving the preliminary investigation, the registration of the offence, period for the registration offence gets postponed. What is the justification? How do you expedite the process of investigation? On one side we say that we must follow Article 21, speedy trials, speedy investigation. No doubt there could be a purpose where there are the false cases were being looked into. In that case, one can possible, but there has to have some clarification, not giving clear powers or ample powers or blanket powers. If he thinks whether the case exists or not, obviously he will refuse it. And he will conduct a preliminary inquiry. Now, how far this would be justified when we say that this Sanhita has been brought into the text or in the statutes for the speedy trial, investigation, fair investigation, and to protect the rights of the citizens? Because the Act itself says a Sanhita to protect the rights. So, a person like me or a layman goes to the police station and says that such an offence is committed, which may be lesser than 7 years. The police officer may say, no, I have to satisfy myself whether the primary case exists or not. How do you counter this? whether this would achieve the purpose, object, some elaboration, some clarification, some explanation was needed while bringing these provisions on the statutes. Now look at the other side. They say that irrespective of the jurisdiction where the offence has taken place, you are sitting in Mumbai, your relative at Nasik calls me up and say that my neighbor had murdered his next door neighbor, or some crime had taken place which is cognizable. I, being very close concerned with the victim who has been assaulted, I pick up the phone and call my local police station saying that such and such offence has been committed. Now they say this has to be done under the zero FIR, and then it has to be transmitted. Again, there are two classifications. A person who goes to the police station and reports the incident or the assault which has taken place outside the jurisdiction, territorial jurisdiction of the police station, and if it discloses the cognizable offence, the police are bound to register the FIR under the zero FIR. They cannot say no. Second aspect. Earlier law was this, that even a communication on the telephone, if for disclosing the cognizable case, the police were required to register the offence. But there could be some cases they might have suffered, and therefore now when the disclosure of the information on the telephone or by the means of communication, electronic communication, by mail and everything, FIR would be registered instantly. FIR would be registered 3 days after when that person comes before the police station and signs that FIR. Now therefore again, there has to be some modalities to be worked out. Should the police sit tight or do nothing when they receive a telecommunication of an offence of a cognizable nature, not to take steps because they have to wait until that is brought on the record as an FIR, because he would have the authority to commence the investigation only when he receives the credible information on his own source or it is brought to the notice. It would fall under the second clause. Now brought to the notice on the telecommunication would be further curtailed by the proviso saying that he has to come and sign the FIR in the police station after 3 days. So how this mechanism is going to work out is the question one has to answer and look into this. The next timeline is under 392, one where judgments were never delivered in time by the transports, and now it is being stated that those are to be within the 45 days and upload the judgment within 7 days. On the lighter side, this is not applicable to the High Courts or to the Supreme Court. The next timeline is on a search report. Whenever there is a search carried out by the investigating officer, then why he has gone to take the search, reasons are to be recorded, and the search report has to be submitted to the magistrate within the 48 hours. That is a welcome change. The another change is the framing of charge within 60 days, I have stated already. And one more change is that if a sanction is not granted, because in many cases before taking so far as the public servants are concerned, or of course under the Prevention of Corruption Act, sanctions are required, but CRPC says under this act, if the sanction is not accorded within 120 days, there will be a deemed sanction. This is one of the welcome changes, but again a deemed sanction is open to scrutiny and a challenge whether there is an application of mind or not, so it may go on. But nevertheless, I must admit and say that some efforts are being made by the legislature to see that some loopholes are plugged. Some pressure or some the officers were now made stand on the toes to see that they discharge that obligation as early as possible. It's necessary. So, leave apart the criticism, there are efforts made to see that there is an early investigation, effective investigation, And one more change is that for carrying out the effective investigation, rather I would say a meaningful investigation, the Sanhita said you must take the help of the forensic experts. As we discussed before coming into this hall, this is a welcome change, but there is again, subject to this, these powers are given to state. The state has to notify when the forensic experts would come and help to collect the evidence, and that notification is required to be issued within the 5 years. I don't find a rational because 1st July we have introduced the act. The time limit, even the state can introduce, set up, maybe for the reason they have to set up the forensic experts or some infrastructure is required to be set up attached to each police station. If there is a crime related to the some cyber crime or some DNA profiles are required, or so many things, blood samples are required. In those cases, or some polygraphy test, brain mapping test, so many things are required to be done. In such cases, though these are on the statutes, but since there are no laboratories available, no infrastructure is available, and probably the parliament or the legislature thought fit that some period was required to be given to the state for raising such infrastructure, so the forensic experts could be taken, their help could be taken for the meaningful investigation, but the period is too long. I don't know why that period has been given. Now the last, because I think I am crossing the timeline, it's at 12:46. Again, the one more thing is that the victims' rights are obviously acknowledged under the Sanhita. We must welcome this. I said earlier the 321, the prosecution could not have been withdrawn, could be withdrawn without the permission of the informant or the victim. Now it is a mandatory under the section 360 that a notice must be issued to the victim before the state applies for the withdrawal of the prosecution. This is a good change. Then the supply of copies to the victim could be even by the electronics means within 14 days. So once charge sheet is filed, when application is made for the bail, the victim could be communicated this charge sheet or informed to her about the charge sheet or the record of the charge sheet by telecommunication within 40 days, intimating the victim the progress in the investigation in the 90 days. Then the copy of the FIR to be given to the victim free of cost. Video recording of the rape victim and the survivor is a really welcome change for 2 reasons. It further adds such statement of the victims should be done preferably at her residence in the presence of her parents or the local respectable persons or the relatives of the victim. If victim is asked to visit the police station for recording the statement in the rape cases, it will be a really embarrassing position for her to disclose the correct information. She would be under the lot of mental tension, pressure, so she may not be able to disclose the correct fact. This is the one reason as to why legislator thought it fit that it should be at her house, so she would be comfortable to some extent. And the second, it is by the video recording. So there is a possibility of tampering her evidence is being taken away. This is a welcome change, that her evidence should be recorded, ensuring the integrity of her testimonies. That is one of the reasons, basic reasons. Then 176 recording so and so, so and so. Then preferably her statement should be recorded by the under the 164. Whenever her statements are recorded by the magistrate, now it is mandatory. It has to be a female magistrate, and when the statements are recorded by the investigating officer, she should be a female the investigating officer, so making the victim very comfortable about it. And so far as the medical the examination of the victim is concerned, it's old section 164A, maybe a new section where consent of the is made mandatory. That consent of the victim is necessary, but so far as the accused is concerned under 53A, the consent is not required. So this is again a difference to be noted. So these are the some of the changes I would say which are brought. The magistrate has been given the powers to directly collect the voice sample. Earlier only the handwriting and the fingerprints were permissible, but now the voice samples could be asked and to be collected, not only from the accused but such other person. After recording the reasons, the magistrate can direct that what samples to be given. So this is one of the supplementing a good aid for the investigation to bring the cogent evidence on the record. The magistrate has been given the powers to levy the fine, which has been increased from 10,000 to 50,000. The offence is punishable less than the 3 years. The fine plus, earlier the fine was 10,000. Now it has gone to the, it has increased to the 50,000. One more welcome change, I would say, that the persons who are over 60-year-old, who are infirm, who are medically unfit, and the women, they need not be called to the police station either as a witnesses for giving the statement. Their statements are to be recorded at their residence. Then offences, this is another good change, that when the offences are punishable for 10 years and more, in such cases, magistrate is required to record the evidence statement under 164, old 164. The new section is the 183, subsection 6. Then I said about the search and other things. Whenever there is a search, he has to record the reasons. Officer has to record the reasons why he wants to take the search. Those reasons are to be supplied again to the magistrate. So these are the supervisory jurisdiction of magistrate is sought to be extended. There will be the close supervision on the activities or the acts done by the investigating officer in the course of the investigation. So there is no manipulation is possible. So this supervisory jurisdiction has been extended, where it says that report has been submitted to the within the 48 hours. This is another timeline which has been stated. And another change is this: the offences which are registered against the public servant in relation to his discharge of his duties, if the complaint is filed against him, then in that case the magistrate is now duty bound or statutory obligation that he must hear the police officer and maybe at the instance of the public servant before taking any steps or issuing the summons. And so there is again a protection to the public servant is afforded. Before I conclude it, one more section I just want to elaborate, and I fall to the saving clause. One more section, that 156(3) was very common earlier, that whenever the police used to were refusing the register of the offence, Priyanka Srivastava judgment is there, which says if he refuses, then one has to apply to the higher officer. A higher officer does not take the cognizance, then that letter along with the affidavit is to be submitted under the 156(3). Application has to be made. Now the 156(3) text has been elaborated. Now that is said that you must give a notice to the police officer. You can't simply come to the court and say that he is not registering the office. That could be some instances where the true facts were not disclosed to the magistrate and resulting into unnecessary burden of the work or the registration of the FIRs. So the court has, this is another good change, that if 156 application with the application and the affidavit is filed in consonance with the Srivastava's case, the magistrate has the powers to inquire into this. If you read a 156(3) old, no powers of inquiry, only satisfaction from reading the complaint and other things. Offence is disclosed, direct him to register the offence. But now, no, now he has to hear the person, hear the police officer, and then pass the necessary order. So these are necessarily good safeguards which are being brought. Now the last, the savings and the repeal clause, which also has some importance. Now what I could see, those are all governed by the section 531 to, yes, section 531. Now this saving clause necessarily says that those are all governed by section 6 and the 6A of the General Clauses Act. Now this Sanhita has not changed the forum. there are no changes as to the where the appeal forum has been taken away and another appeal forum has been introduced, or the first appeal has been introduced and second appeal. Nothing like that has been done. So therefore we need not go into all these things. What we are required to see, what will be the effect and what the provisions would clearly say. So 531(2) subclause A says, before the new act came into the force, if any application, appeal, trial, inquiry, investigation is pending, word is the pending, it would govern by the old law, that is CRPC. Second says all notifications published, proclamations issued, powers conferred, forms provided by the rules, sentences passed, orders and the rules, and appointment made, deemed to have been issued under the code, under the corresponding provisions of the Act. So notifications which are issued by the High Court, notification is defined. If the sentence is given or the forms under the CRPC would be the same form as if those are issued under the Sanhita. So no change. Sanction accorded and the consent or consent given but proceedings not commenced, possibility. On the 1st July, the Sanhita came into the force, but sanction was given in the month of May. What would be the result? The result, the Act clarifies, it deemed to have been accorded under the code and the proceedings may commence under the Sanhita. So those are validated and there is no embargo for commencement of the trial under the new Act. And lastly it says, for example, under the before the 1st July, some order was passed on the 1st of March against the accused. The accused has a right to file an application to set aside that order within 60 days. So March and April, or for example, we say that we take it at the 1st April, order was passed on the 1st April. The time to revise or challenge that order under the old Act, hypothetically, it was 60 days. So April 30 days and May 30 days. 1st June was the last date. He did not file the application. But a corresponding limitation if extended for 120 days under the new Act. He cannot say now the order is passed on the 1st of April, 120 days now at my command. So therefore limitation stand is extended. That is not permissible. Once it is lapsed under the old Act, it will not revive because extended period is provided under the new Act. So his remedy would be against under the old Act, either to apply for the condonation of delay or whatever is the permissible. So the saving clause is not much bothering, would bother or come in any way. But all other things which I have tried at my best to explain to you, I think I tried to give the overview as to timeline, the broad changes which are brought, and procedures in the investigation, police custody, cognizable offence, non-cognizable offence, and other things. Of course, several judgments, Lalita Kumari, I did not mention to you. Arnish judgment is already there. The powers of the police in case of the offences more than 3 years, 7 years, what he has to do, when he has to issue the notice, those are being kept completely intact. 7 except some timelines are provided and nothing more than that. So I believe some efforts are being made at my side to place whatever is possible, what I could read and understand. And I repeat, all these views are my personal views. You may agree, you may not agree until some judicial pronouncement comes. Thank you very much.
To address you all today on the subject of the Bharatiya Nyay Sanhita, a transformative piece of legislation that aims to revamp our justice delivery system. The new law, which uses the word Nyay, means justice. While bringing numerous advancements, also presents certain challenges that we must recognize and address. In due course, judge-made law will iron out the creases. This is the famous saying of Lord Denning, that the judges always iron out the creases. and make sense of what the legislature planned for us. So what I plan to do during this presentation is, I will touch on only some sections which are impacting us almost on a day-to-day basis, and also put certain seeds in all your minds, because if as Justice Shinde put so many seeds in our mind and we started thinking, and I'm sure all of us would have made our notes and said, no, Justice Shinde spoke about this point, Justice Shinde spoke about this point, what would be the implications? Justice Shinde said this will be perhaps the implication, but this also could be the implication. So basically, when you call us a resource person, you want us to implant seeds in your minds, fertile minds. We Indians have very fertile brains, so that we keep on thinking, because law has to evolve. Law cannot be stagnant. So therefore what I have done is that I have made certain points which I will read out to you in a very slow way, so that what my thoughts are on some of the points, and then I will share my presentation also later on, so that you also can go through it independently on your own. So you don't have to really make any notes or scribble down something very fast, because I'll be sharing my presentation with you also. Knowledge, as they say, increases only when it is shared. Nobody has a IPR right on that. So now let us delve into the fine nuances for certain provisions of the BNS which would impact us as lawyers, litigants, or the police and other agencies. Few days back, the Punjab and Haryana High Court has declared that using the abbreviations BNS, BNSS and BSA is perfectly permissible. Interestingly, Section 4 of the BNSS inter alia states that all offences under BNSS shall be investigated, inquired into, what Justice Shinde last said. So why do we need laws? Let's go to the bottom of this. Let's lay the foundation of this presentation. Why do we need laws? Why do we need courts? Why do we need an independent judiciary? Why do we need the state to appoint prosecutors to conduct trials? As in any crime, there is a victim and the offence is committed against the state. Is it not the job of a prosecutor to ensure conviction or to place all the relevant materials before the judge in all fairness? Our jurisprudence has evolved, and only because of the extreme hard work and the wisdom of our judiciary. We are blessed to have Justice Shinde with us. In the context of India's legal evolution, the BNS now will shape the nation's criminal justice delivery system's future landscape. The preamble of the BNS is as follows: an act to consolidate and amend the provisions relating to offences and for matters connected therewith or incidental thereto. Now, what is the historical background of criminal laws in India? The Indian Penal Code defining crime and prescribing appropriate punishment was drafted, as we all know, on the recommendations of the first Law Commission of India, established in 1834 under the Chartered Act, under the chairmanship of Lord Macaulay. It came into force in the subcontinent during the British rule on 1/1/1862. However, interestingly, it was not enforced in the princely states and remained on paper for long. The princely states were almost 500 in number and were cleverly divided and ruled by the British monarchy, who had their own courts. The rulers had the power of life and death over its helpless citizens. The rulers regularly issued absurd verdicts like desh se nikalo, death penalty, etc. Many verdicts were completely based on perception, without any basis. only with a view to frame certain persons. Lot of emphasis was based on which caste or community the opposing parties belong to. All this was needed to be streamlined and equally applied what British ruled India. Much later, as time progressed, the IPC started being applied across India. We all know about the historical mistrial and the gross miscarriage of justice committed against the very Honorable Bal Gangadhar Tilak in courtroom 46 of the Bombay High Court. Hence, the manner of application of any law is of great significance. Justice Shinde also emphasized the application, the implementation, and not selective in nature. That was his emphasis. The IPC was amended several dozens times, and we had committees like the N.N. Bora Committee, the Justice Malimat Committee. It was a huge and mammoth exercise. The committee, that is Malimat Committee, opined that the existing system weighed in favor of the accused and did not adequately focus on justice to the victims of crime. Many reforms were suggested. I will not go into the reform part, but it was a long-term strategy. The interesting aspect is that it was a penal code, and now we have a Nyay Sahita. Now let us see what is the brief overview of the IPC. The IPC codified a wide spectrum of criminal offences, encompassing acts from homicide and theft to fraud and public order disruptions. Its comprehensive nature has guided judicial proceedings for over a century, anchoring the noble purpose of dispensation of justice. Thousands of judges over time, presiding over various courts, have interpreted and delivered judgments which have withstood the test of time. It is my personal opinion that most of the provisions which have been adopted and grafted in the new BNS, almost 95% and plus, which clearly derive their inspiration from the IPC, would still be interpreted by the case law delivered under the IPC regime, as we must never allow this treasure trove of case law to be forgotten unless the appropriate court notices an apparent conflict in any manner. The IPC contained 511 sections with numerous state amendments. The BNS contains 358 sections in 20 chapters, completely streamlined for easy reading and convenience. Now let us shift to the BNS, because that is what we are here for. Thank you. The introduction of the BNS marks a departure from the IPC's Victorian era constructs, embracing a contemporary framework tailored to India's current socio-economic landscape. This legislative shift aims to address emerging challenges such as cybercrime, environmental offences, mob lynching, organized crime, abatement outside India for an offence to be committed in India, which is section 48, I'll come to that later, thus extending BNS beyond our borders. Sexual intercourse by employing deceitful means, gang rape, hiring or employing or engaging a child to commit an offence, causing death by negligence, procuration of child for sexual illicit intentions with another person, section 96, petty organized crime, terrorist act, kidnapping, any act endangering the sovereignty, unity and integrity of India, attempt to commit suicide with intent to compel or restrain any public servant from discharging his official duty, forgery of court record or record of court as you call it, or of public register, statements inducing public mischief, that is these days we see spread of fake news, crimes against marginalized communities, which are some of the highlights which I will come to. The sections also have been chronologically changed. For example, murder was 302 under IPC. Now it is 101, though there is no change of language. Section 358 of the BNS lays down that though the IPC is repealed, it will not affect any investigation, inquiry, etc. That is the savings clause. And in fact, few days back, almost 2nd July, Punjab and Haryana High Court has also given a judgment on that. So we lawyers are very fast in approaching the court for a declaration of the law on that subject. Chapter 2 contains interesting definitions: child, documents, and transgender, etc., which I will come to later. In the IPC, there were scattered offences against women and children. Now they are all under one chapter. Let us first start with section 152 of the BNS. One of the significant changes in the BNS is the removal of the colonial law of sedition, as was enshrined under 124A of the IPC. However, it must be noted that section 152 of the BNS retains the essence of section 124A, and my professional brothers and sisters, during discussions, unanimously opined and hoped that this provision was better worded. Law, especially criminal law, has to be crystal clear in its meaning and what it seeks to convey. Any ambiguity in conveying the intent can lead to confusion, which is never the intention of the lawmakers, and thus adds to the burden of the courts and can lead to miscarriage of justice. The phrases, these are very important phrases: subversive activities and endangers sovereignty in section 152 have not been specifically defined, which may render the application and implementation of this provision highly problematic, wherein an individual may be arrested or investigated based on a misinterpretation of the BNS, which will only ultimately be rectified by the judiciary through a case before it. Therefore, there is a lot of potential to curtail the liberties of vast multitudes of people. Corruption in the police machinery is another problem which perhaps no law on the planet can curtail. The misuse of provisions, deliberately misapplied, and framing of innocent people by creation of record is another serious problem we face on a day-to-day basis. The BNSS, on the other hand, parallelly has tried to tackle this problem with provision relating to strict maintenance of case diary, etc., which Justice Shinde spoke about earlier, and completion of the investigation. 152 of the BNS, and I am emphasizing this again, in very concise manner expands this concept and covers a wide spectrum which includes person who excite or attempt to excite by subversive activities or encourage feelings of separatist activities to endanger the sovereignty or unity and integrity of India, which is punishable with imprisonment for life. Again, whether any healthy discussion not agreeing with a certain view would be liable to attract 152 is like running on a razor's edge. And once again, we will have to fall back on the wisdom of our judiciary when challenges come up for consideration in due course. Friends, recently, and I'll share the judgment also with you, recently, the Honorable Division Bench of the Bombay High Court in the case of one Parvez Vaid and Faiz Bhiwandiwala. Now with social media, live law, bar and bench, all of us have access to latest judgments. In few minutes, the entire world knows how Indian courts are delivering judgment after judgment. But this judgment is delivered on 11 July of this one, dealing with UAPA as well as NDPS. Released both these accused on bail. It was only due to our vibrant and vigilant judiciary that justice was delivered However, due to certain problems like overloading of the or docket of cases, adjournments, justice is delayed most of the times. In this particular judgment, the Honorable Division Bench has inter alia held that just because some persons have stated that these two accused knew Dawood Ibrahim and referred to Parvez as a member of the D gang, it could not be held that he is a member of a terrorist gang or organization, and on the basis of the material placed on record. The court took pains to go through the entire record, and justice was delivered by grant of bail. Now let us see the overlap with the UAPA, because what is happening over here is that in two cases specifically, MCOCA and UAPA, I see two sections running parallelly, which I want to present before you and leave you all with some thoughts. The Terrorist Act, the word Terrorist Act is defined under UAPA as well as unlawful activity. The definition of Terrorist Act under BNS is at section 113, goes far beyond and covers a wide spectrum of criminal offences and is an inclusive definition. It delineates clear boundaries to prevent misuse and also uphold constitutional rights. 113 introduces heavy punishment and also covers persons who conspire or abet the doing of these criminal acts. According to me, it is a vast and expansive provision covering a variety of offences, as also in subsection 4 covers a person who threatens the economic security of India, causes damage to the monetary stability of India by way of production or smuggling or circulation of counterfeit Indian paper currency, coin or any other material. We all know about the printing presses in countries like Pakistan, where our currency is printed and smuggled for distribution in India. This path-breaking provision extends the definition of Terrorist Act much beyond UAPA. The only fear is misuse, as now there are two laws running parallel for the same alleged offence. There is an explanation that an officer not below the rank of SP shall decide whether to register the case under this provision, that is 113, or under UAPA. Again, judicial scrutiny therefore is extremely vital in such situations. Now let us see MCOCA and organized crime, qua the BNS. Under section 111, the BNS Act deals with the menace of organized crime and defines continuing unlawful activity and organized crime syndicate. The term organized crime is also defined in the specialized state legislation as MCOCA. Other states also have similar statutes on the same lines. Section 111 of the BNS, while dealing with the term organized crime, includes several instances, situations and terms such as land grabbing, contract killing, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom. It is again an inclusive definition. Again, our vigilant judiciary will be approached time and again to solve problems and deliver justice. Now let me take you, because I am just going through the sections one by one so that you all can write down which sections of importance that you thought more emphasis is to be laid, then we can discuss later if necessary. Now let us see section 180. Section 180 prescribes punishment up to 7 years or more for possession of forged or counterfeit coins, stamps, currency notes and bank notes, knowing or having reason to believe the same to be forged or counterfeit and intending to use the same as genuine. Further, section 180 in its explanation clarifies that if a person establishes the possession of forged and counterfeit coins, stamps, currency notes and banknotes to be from a lawful source, it does not constitute an offence. Hence, innocently, one could land up with a fake currency note, and this explanation helps the innocent possessor. Now, let us come to a very draconian provision, that is section 63, which deals with rape. Section 63 deals with the heinous crime of rape. However, in exception 2, it states, sexual intercourse or sexual acts by a man with his own wife, not being under 18 years, is not rape. Under 375 of IPC, it was 15. So marital rape is still not a crime. Section 377, which dealt with unnatural offences, that is consensual carnal intercourse and bestiality, is called the animals, under IPC, has not been brought back in any form. Maybe the Parliament will have to consider this aspect after discussing with various stakeholders, criminal lawyers, former honorable judges who have considerable experience, and other intellectuals who can contribute their ideas as forcible carnal intercourse against a man and bestiality should be considered according to me as serious offences. We all know the landmark judgment of Navtej Singh Johar. I am sure most of you all must have gone through that judgment. Let us come to adultery. Also, the provision of adultery has now been brought back under section 84 of the BNS, which penalizes a man for enticing the wife of another man so that she may have intercourse with any person. In 497 IPC, the word enticing was not present. We all know about the judgment in the case of Joseph Shine. Again, a landmark judgment. If you all have not read it, I'll give you the citation, you all must go through. And the offense of adultery was decriminalized. Lot of debate is going on this aspect, as such provisions should be gender neutral. I'm not raising a debate over here, but I feel that lot of offenses should be gender neutral, which has not happened in BNS. I leave it to you all and your views. As it is an open house today, everyone is free. Now let us come to 69, section 69. See, what happens is that, as Justice Shinde also would agree with me, that, and my other friends over here, that you have today podcasts, you go on any of this platform and you have hundreds and hundreds of podcasts. In fact, now people who are aspiring for judiciary, they are also having courses. So you have lectures, 1.5 hour lecture series, and 25 parts. So all knowledge is available. I am not going to be trying to say something that already has been said in all those podcasts, because most of you all must have gone through those podcasts. My job over here is to only show certain nuances of certain provisions. Let's therefore see section 69. Don't ask me which ice cream it was. Section 69 is a very important addition, as it introduces an offence which was not present in the IPC. The offence of sexual intercourse by employing deceitful means or by making promise to marry a woman without any intention of fulfilling the same now shall be punishable with imprisonment, which may extend up to 10 years. What is deceitful means? Define. Shall include inducement for or false promise of employment or promotion, or marrying by suppressing identity. The deception or deceit, according to me, should be from the outset. It is evident that this is again not gender neutral. And what if the woman is given the job or promotion? The question is, then is that sexual favor justified? Is it not a misogynistic mindset? These are questions that require serious debate and discussion. The Supreme Court in various judgments has quashed proceedings under the erstwhile 376 of IPC, where FIRs were registered, alleging rape, where relationships became sour. If evil intent was evident from the outset, that is from the inception, then the offense is committed. But there have been cases where after few years in a relationship, things were not working out at that stage. If the woman alleges rape or now files an FIR under 69 and ultimately it is proved that none of the ingredients could be proved by the prosecution, who will bring back all the years of prison time, suffered loss of reputation, the stigma, and the entire family going through hell due to media publicity? We all know how media trials are conducted mostly without control, and only TRPs is the criteria on a daily basis. Let me now take you to section 95. Section 95, and this is somewhat, I would not say exactly, we all have read about the Hinduja case in Switzerland that happened, about the Hindujas, about employing and then exploiting their domestic help. Let us now keep that in the background focus and see sections 95. Section 95 deals with hiring or employing or engaging of a child to commit an offense. The imprisonment may extend up to 10 years. Section 2 into bracket 3 of the BNS defines a child as meaning any person below 18 years. See the dichotomy which arises. Inasmuch as the so-called child who under the Juvenile Justice Act is also a child under 18 years is sent to reformative environment, and we all know about the Pune Porsche case where so-called juvenile was asked to write an essay and got his freedom in spite of the death of two innocent people. I think today's paper carries that the charge sheet has been filed. So the situation now arises, and I leave this to the open house. If the child will be sent to remand home, and the person who engages the child will suffer imprisonment which may extend up to 10 years. I personally feel that the Juvenile Justice Act needs a serious relook in view of what is happening around us. Let me now take you to another provision which is 106, rash and negligent driving, 1062. 1062 was incorporated, and the punishment for causing death of any person by rash and negligent driving not amounting to culpable homicide, and a person who escapes, he has to escape without reporting to the police officer or magistrate, is punishable up to 10 years. This is a serious problem we as a society are facing. Since the blood test, again in the Pune Porsche case that was a problem, which is a very vital piece of evidence, was not conducted forthwith. The culprits try and take shelter on a technicality, but again the judiciary will not spare such people as the presumption completely turns the tables. At this moment, this particular provision is on a holdback status because of the truck driver's agitation. There says that there is poor visibility, many times we can't see, there could be some drunken villager that just went across. What do we do? So just now that is at holdback. But this will again require consideration at some stage or the other. Let us turn to 1032, and before I go to 1032, let me bring to your notice that while punishments for various offences have been significantly increased, one of the most notable changes is the enhancement of punishment for causing death by rash and negligent act. Previously covered under section 304A with a maximum sentence of 2 years, this offence now carries a penalty of up to 5 years under 1061 of the BNS. And in case of a medical practitioner, specifically it is worded, medical practitioner, if such an act is done while performing a medical procedure, on conviction, he shall be punished with imprisonment which may extend up to 2 years with fine. Now 103. 103 covers mob lynching. We have seen in the newspapers, on TV channels, so many incidents of mob lynching. Now what is mob lynching and how it is defined under 103? It covers the menace of mob lynching and deals with situation of murder of a person, murder, by a group of 5 or more acting in concert on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar grounds, which is punishable by death or imprisonment for life. In the alternate situation, where mob lynching causes grievous hurt, section 117(4) says that it may extend up to 7 years. So both the situations are covered. And it also says that if a person, the victim, goes into a comatose vegetative state, the imprisonment then can extend up to life under 1173. We had a very, very unfortunate case. I'm slightly diverting from the topic, I just remembered. When we were growing up, there was a nurse in JJ Hospital, sir, you would remember. The most unfortunate, one of the most unfortunate cases that one could think of. And ultimately, I think few years back, she passed away also. So in such cases, I think it would be the rarest of rare cases, and the criminal do require death in the penalty. But then ultimately it is now for the judges and the Honorable Parliament to decide. Let's come to 137. 137 deals with the crime and offence of kidnapping. This is Firoti, kidnapping, all those kind of things we see in these OTT serials these days. One in Mirzapur, everybody is kidnapping everyone in the village. We see that. So now kidnapping is under 137. States that whoever entices or takes away any child or person of unsound mind out of the keeping of the lawful guardian is said to kidnap the child. 137 deals with kidnapping of two kinds. Kidnapping from India and kidnapping from lawful guardianship. The earlier sections dealing with kidnapping in the IPC were 359, 360 and 361. Now the age will be uniform, as section 2.3 defines child as any person below 18. IPC had different ages for man and woman. 226. Article 226 is most important section under the Constitution, which enables all of us lawyers to earn our bread and butter by filing writ petitions. 226 of the BNS deals with attempt to commit suicide or restrain exercise of lawful power. Very interesting. This is an interesting provision. Why? As it covers any person who does drama or creates mischief and a fake situation or attempt to commit suicide with intent to compel or restrain any public servant from discharging his official duty. It punishes that person with simple imprisonment which may extend to 1 year or with fine or with both or with community service also. I will come to community service later on. There are many cases where persons to abscond in the middle of a created situation make a fake attempt to commit suicide, thereby distracting the public servant, and now such oversmart people will face the music. Let us now come to a very, very heinous offence under 337. 337 of the BNS covers the heinous crime of forgery of document or electronic record including record or proceeding of a court document or an identity document issued by the government, including voter identity card, Aadhaar card or register of birth. The imprisonment may extend up to 7 years. Just a few days back, a lady was impersonating as an advocate. It came in the newspapers. And the Sessions Court rejected her bail application as she had defrauded several individuals by falsely claiming to be a Supreme Court advocate. There were 11 criminal cases registered against her in Maharashtra and Haryana, and she provided false residential addresses and various other documents, committed various offences including pressurizing witnesses. It is also possible that such kind of people can go to any extent and also forge court orders, and in many cases are exposed also. Such persons deserve severe punishment, and this provision also contains such list data also maintained in electronic form under IT Act 2000. Let me now come to 353. 353 covers statements conducing to public mischief, and these days we see a lot of social media messages or artificial intelligence generated images portraying a completely different situation, and in many cases it has been found that such statements contain false information and rumors which are all fake news. Such mischief may cause serious law and order problems, including defamation against the person who is targeted. Many celebrities suffer from a deep fake situation. You've read about the deep fake situation. And hence 353 provides imprisonment which may extend up to 3 years. Under the IPC 504 to keep up with the changing times. We all know that in Delhi and I think in Bombay also, many of the celebrities, known faces, have approached the court for injunctions in the case of these deep fake situations. Let us come to section 70 now of the BNS. The provision of 376 DA of the IPC dealt with the situation of gang rape, which has now been expanded in the BNS in the form of section 72 into bracket 2, wherein a major change is the alteration of the words from under the age of 16 to the age of 18, thereby expanding the scope of the offence by bringing more cases within its purview. Gang rape is a heinous crime and life imprisonment has been prescribed in such a situation. As far as gang rape is concerned, where the woman is above 18, the punishment shall not be less than 20 years, which may also extend to life, which shall mean imprisonment for the remainder of that person's natural life and with fine. The section is very, very clear on that. Section 75 deals with sexual harassment. Section 76 deals with use of criminal force to disrobe a woman with intent. Section 77 deals with voyeurism. We know all those peeping toms and those kind of perverts, so it covers those kind of people. Stalking is under section 78. Many women face the situation of stalking, so that is covered under 78 of BNS. Now let us come to something different that has now come in this BNS, that is community service. As a new addition to the chapter on punishments, community service has been added as one of the reformative punishments that may be given on the conviction of a person. It must be noted that community service as a punishment, according to the statement of object and reasons, is only for petty offences, and therefore is given in the BNS only under certain categories of offences as a means of punishment. Again, we have to rely on the wisdom of our judiciary as what would constitute community service, as it is not defined. But we also want to avoid the stigma and the humiliation because it is reformative in nature. So we have instances where courts have directed that you will work in an old age home for 3 months, or you will plant 100 trees, those kind of orders. But the service as such has not been defined. What is the scope? It is completely left to the wisdom of our honorable courts. Friends, the stream of justice should be uninterrupted, pure and clear. Certain provisions exist in 2 statutes, and ultimately will have to coexist and will have to be given purposeful and meaningful interpretation. Careful scrutiny of our courts by way of judicial review and in the manner and process of implementation will ensure that the executive is kept in check. The wide discretion given to the police is a matter of concern, as since the time of Lord Macaulay also, it was a known fact that police authorities are known to twist facts and regularly frame innocent people. Hence, statement before police officer is not simply admissible and has to be proved. The BNSS, according to me, is a good exercise in that context. Friends, why are the jails bursting? Now let me put some questions to you. Why are the jails bursting beyond their capacity? Full of under trials. Justice Shinde will bear me out over here. Many convicted hardcore criminals choose to remain in jails as a safe custody on some pretext or the other and convert newly arrested under trials to the jazzy world of crime. Easy money is the perfect bait. The burning question today we as a society need to think is why the fear of punishment and custody is not existing in thousands of our youth who are turning to crime on a daily basis. The court infrastructure needs a complete overhaul, especially the lower judiciary. The lower judiciary courts are seriously handicapped. I can say that because I have practiced regularly in magistrate sessions courts and I see the problems. We also need more judges at all levels, considering the size of our population and the pendency of cases. I was just doing some research in the morning to bring it to your kind notice. The law minister has informed the Rajya Sabha a few days back that against the sanctioned strength of 1,114 judges in various high courts, 757 judges are working. That is 68%. 357 posts of High Court judges are vacant. That is 32%. Considering the amount of population per square kilometer, do we have enough judges? That should also have been a concern, and that will always remain a problem. These are questions which don't have an easy answer and would require deep introspection and an all-round effort by all of us, failing which we are going to spiral into a deep abyss for which there is no return. An interesting provision is made in respect of 307 which deals with theft. When we were on the dais, from that particular black purse, I don't know whom it belongs to, a mobile started ringing. And Mr. Bhatt took out that purse in his hand, took out the mobile, and perhaps put it on silent. If I was a police officer, I won't take it further. In case of theft, where the value of the stolen property is less than 5,000 and a person is convicted for the first time, shall upon return of the value of the property which he returned or restoration of the stolen property shall be punished with community service. I feel that there should be no cap on this amount. As if a person has remorse, and if he feels that he has made a mistake, he returns and realizes, then there should be no cap that it should be 5,000 or 10,000. Section 304 deals with snatching, which has now come in BNS in order to commit theft. Just to leave you all with some more seeds of thought, the offense of attempt to commit suicide has been deleted in the BNS. It's not there in the BNS. This is also in view of the Mental Health Care Act of 2017. Implemented in letter and spirit, and may our justice delivery system once again rise to the expectations of the people. I hope that I have left you with some few seeds of thought which have already started sprouting. Jai Hind. Thank you.
Thank you, sir. Gratitude to sir for being a part of such a momentous part and elaborating the law so vividly that we can also relate, and you were relating to real life cases that made us connected with the law, and this law would be remembered by us with the case studies after this session very vividly with all our participants. Thank you, sir, for sparing your time for such a wonderful certificate course with GLC and Chamber of Tax.
In fact, I must personally also thank Justice Shinde because he so elaborately and eloquently explained his topic to all of us. Thank you, sir, once again.
So, thank you, sir. Please accept our gratitude from GLC and Chamber of Tax Consultant for such a wonderful session. And before I can announce a lunch break, I would like to announce that Chamber of Tax Consultants, you all can also become a member of the Chamber of Tax Consultants
sector. In 1979, inspired by Lok Nayak Jai Prakash Narayan's call to action, he ventured into the tribal areas of Raigad district, addressing critical issues like bonded labor and implementing alternative education systems for illiterate tribal people. Starting his law practice in the Small Causes Court, Mumbai, with his father, late Lakshman Patil, he later joined the chambers of late Mr. Justice Vilas V. Kamath and the Bombay High Court. Following Mr. Kamath's elevation to the bench, Mr. Patil began his independent practice, covering a broad spectrum of legal fields, including constitutional law, civil and criminal law, industrial law, and family law. Mr. Patil has handled significant cases such as writ petitions on GATT agreements, Dunkel proposals, the Enron project, and the Tarapur rehabilitation case. Notably, he assisted in the criminal trial against the then Chief Minister Mr. A.R. Ranthule and continued to work pro bono on the Tarapur Power Project rehabilitation case. From 1985 to 1989, Mr. Patil also shared his knowledge as a faculty member at KC Law College, Mumbai, teaching the Criminal Procedure Code and Indian Evidence Act. His service as Additional Public Prosecutor for Maharashtra from 1996 to 2001 saw him handle numerous critical cases, including death sentence appeals, police encounters, and habeas corpus petitions. A distinguished member of the Bar Council of Maharashtra and Goa, Mr. Patil served as its Vice Chairman and later as Chairman, where he made significant contributions to the legal community, including the establishment of 380 e-libraries and the continuous legal education program for young advocates. He has also been actively informed with the Maharashtra State Law Commission, the Advocates Association of Western India, and several international legal associations. His outstanding contributions to the legal field were recognized when he was conferred the title of Senior Advocate by the Bombay High Court in 2012. An experienced mediator, Mr. Patil has been on the Bombay High Court's panel since 2005 and has played a crucial role in regional conferences across Maharashtra. Outside the courtroom, he is an avid sports enthusiast and serves as the Honorary Secretary of the Bombay Advocates Cricket Association. Please join me in welcoming Mr. Rajiv Patil, whose dedication and contributions to the legal profession and society continue to inspire us all. We are privileged to have him lead our session on the Bharatiya Adhiniyam today. Before we proceed, I would request our Dr. Asmita Vaidya to felicitate our today's speaker, Mr. Rajiv Patil.
afternoon, everybody. I hope you had good sumptuous lunch and trying to concentrate on me now. I promise all of you, as I was a lecturer for quite some time, my limit is 40 minutes, not beyond that. So don't worry, I am not going to stretch it too far, but I must make it very clear to all of you. Being from the old school, I am not electronically or technologically literate. You can call me as an illiterate person so far as that side is concerned. But so far as today's subject which is given to me is very close to my heart. And I always believe that once you understand the basics of any law, procedural or otherwise, whatever may be the changes, you can easily receive those changes without any difficulties. Because if you're in my college days, we used to call it, if your fundas are clear, nobody can stop you. So your basics, if your basics are clear, there is no difficulty in understanding any law as such. In fact, I am really thankful to Mr. Shyam, Valve and Nyay for giving me this opportunity to make myself presentable before you. I must share one of my experience. If at all, if you are from Government Law College, today you have the best principal to whom I know for at least last 10 years. She is the best principal, and I attended various programs with her on various forums. When I was discussing this topic with Mr. Shyam Valve and Nyay, they gave me a framework on which I am supposed to, or which points which I am supposed to touch. They told me I must refer to brief overview of Indian Evidence Act, how the shifting takes place, what are the issues with definitions, facts, primary evidence, secondary evidence, electronic evidence, digital signatures, presumptions, documents, examination of witness, and what is the effect of repeal. Friends, I must make it very, very clear to all of you. When, as I said earlier, if you have studied Evidence Act from whatever year, the issues you have understood what required in Evidence Act, what is the evidentiary value of any fact or the piece of evidence. So we are today deliberating on new enactment called Bharatiya Sakshyam Adhiniyam 2023. I may refer to it as a New Evidence Act. If at all I have to touch the Evidence Act, one must have a brief history. One must know about the brief history of the Evidence Act. Whatever I studied, I am just trying to place before you. To best of my knowledge and information and whatever I studied, the Britishers or all the Commonwealth countries enacted law of evidence around 1860. Around 1860. The law of evidence is consistent with everywhere, consistent with British ideas of or British principles or Commonwealth principles, but with adaptability to Indian society. Because when it came for enacting a law for India, they basically went through what are the requirements in their law which can be adapted in these countries for smooth sailing of judicial forums. When we talk about the Evidence Act or law of evidence, let me not say that Evidence Act. We need to divide this subject in 4 questions. It's not far beyond that. Nyay told me that when she was studying Evidence Act, she found it very complicated. No ma'am, it is not a complicated law. If at all you want to compare it with your Indian system, and if at all we wanted to have original Indian law, then we should have studied the science called Tarka Shastra. Tarka Shastra is a science of logic or whatever is the subject which requires a supporting material to prove your point. But we are not going into that issue. We are trying to understand what are the 4 questions which are very, very important so far it relates to law of evidence. There are 4 questions are like this. What is the evidence given of? What is the evidence which is to be given? The answer is very simple. It's of the facts. Facts in issue or relevant facts would be the proper answer, because evidence can't go beyond the facts. And if you want to prove the facts, there is a procedure followed in the Act, either a new law or the old Act. Now the second question is, how evidence of such facts is given, how it is to be given. Simple answer, oral or a documentary evidence. These are the 2 ways to give evidence. Either you can give oral evidence or a documentary evidence. And while giving this evidence, who is responsible to prove that evidence, or we call it a burden of proof, with whom it lies? It lies with the prosecution. Prosecution doesn't mean the criminal law. Whoever prosecutes in a civil suit, if at all the plaintiff wants to prove, he has to prove his case. If defendant wants to come up with some case, the burden shifts. But let us not go into who is the best person to give evidence. And the 4th is, what is the evaluation of the facts? Because you collect the facts, place it before the court in support of your contention, in support of your case. And what is the evaluation of fact? The answer is very simple. Evaluation is to prove or presumption or presume or disprove. May presume, shall presume are the terms you come across, which leads to conclusiveness. You conclusively reach to an answer. You reach with some that conclusion on the basis of facts which are placed before you, whether which are proved before you. And that's the evidence you need to consider for the purpose of proving. The one more thing about I said all these things because everything is revolved around these 4 questions. Little bit more history. A British monarchy thought it fit to introduce all the legislations in India which were suitable to the civilization where they wanted to rule. The countries which are now known as Commonwealth countries as such, it was made applicable to all those countries, and by Charter Act of 1833, by authority of Governor General in Council, which enacted various laws from 1834 to 1920. This is the period, the basic or the required enactments were introduced. The Charter Act enabled the governor, and he thought it fit to first establish a law commission for the purpose of nature and operation of all laws, including customary law, prevailing or in force in any part of British India, to which any inhabitant of this country was then subject to prepare a report and advise Legislative Council on the matters of law. I don't know whether in my college days it was said Lord Macaulay was the person who is father of Indian Evidence Act. Lord Thomas Babington Macaulay was the first law member along with 3 others who started making these enactments like penal code. It was sometime in 1837 it was enacted. Limitation law 1842. Pleadings and procedure 1848. Then thereafter there was 2nd, 3rd and 4th law commission till 1879. And during this span of 50 years, these law commission contributed a great deal in respect of Indian statute book. The prevailing English law adapted to Indian conditions, they were Code of Civil Procedure, Indian Contract Act, Indian Evidence Act and the Transfer of Property Act with these first 4 law commissions. Now one must appreciate, because I believe in that, the Indian Evidence Act, which was first formalized in 1860, took formal as an enactment in 1872 or 78, And this act smoothly governed the evidence in courts of law for 2 centuries. Two centuries, it's not that 2 decades. Macaulay and others thought of all the possibilities and created this Evidence Act, which, barring few exceptions like development of technology, it remained unchanged with its basic principles for more than 2 centuries. Of course, in 1973 there was overhauling of procedure codes, like Criminal Procedure Code came into, new Criminal Procedure Code came into 1973 and the all others. But however, till 2024, the law of evidence follow the same principles which are not changed. Now, I am not a political person, but there was a political debate saying that archaic British laws are changed. British and British was the word which was always used, that ruled India, and we should throw away this British inheritance in all new way or the Indian way. But according to me, this is my personal opinion, because it is consistent with the principles of law. According to me, Bharatiya Sakshyam Adhiniyam is not creating any revolutionary enactment. I'll tell you for this reason. I will try to make it very simple. In the entire world, there are different types of jurisdiction. In European countries, there is some difference in proving certain facts. We go by a typical English thought that burden of proof is on the prosecution. If at all you want to prove a particular fact, it is the burden on who asserts that this is the fact. It is not the burden on the other side to disprove the case of the person who is trying to assert. For example, in some European countries, if at all we touch the criminal law, the burden is on the accused person to prove that he is innocent, which is not the fact in Indian scenario. And therefore I am saying, from different jurisdiction. But I would say, I will appreciate that a nation always need to proceed further with new look towards their own laws. And therefore, maybe the principles are same. The lawmakers thought it fit to evaluate the entire thing and once again place it in a proper way for the purpose of smooth functioning of a judicial forums. Because a small example I'll give. After the introduction of IT Act, there was a change in scenario, how to prove certain facts. So the lawmakers had to take a note of that and had to make amendments or add something in the act to facilitate the proof of that. So therefore, we are just trying to, I am not saying, please don't misunderstand me. I am not suggesting that there is nothing in the Bharatiya Sakshyam Adhiniyam. Sorry, I take some time to get used to this kind of nomenclature. Not because it's in Hindi or Sanskrit. We should get adaptable to the situation, that what in Indian way we follow. So therefore, yes, if at all the basic principles are maintained, there is no difficulty about the changing the Evidence Act as such. As I said earlier, the foundation remains the same. That is the 4 questions I placed before you. Basic principle is one has to consider what is fact in issue or what is matter in issue. Hearsay evidence has no place in Evidence Act. I heard it and therefore I say this. Is not acceptable to the principles of law of evidence. Nowadays we are keen to believe the media. And when I hear too many channels, I get confused which is the fact. Am I trying the fact in issue, matter in issue, or I am receiving the pieces of evidence from different persons by different versions? So therefore, there is an authority which is court of law or the judicial forum or quasi-judicial forum where these principles are followed, and by adapting the new situations, we are trying to look at this Bharatiya Sakshyam Adhiniyam. So far as law of evidence is concerned, the modalities and rules whereby the courts evaluate any evidence while adjudicating the case, whether it's a civil case or it's a criminal case. I am restricting myself to civil and criminal because there are different jurisdictions. For example, Family Courts Act. Though you have to follow the principles of evidence, law of evidence, it is not necessary you go strictly by law of evidence. Similarly, in labor legislation, there are similar things. But in criminal jurisprudence like ours, which are adversarial and not inquisitive, it's adversarial and not inquisitive. The court is not to find out actual culprit, but to ascertain, only to ascertain the guilt or the innocence of the accused person, if we want to say in a criminal jurisprudence. The scope of law on evidence is much wider amplitude in the inquisitive jurisprudence, and therefore let us not complicate it, but understand easily. If we have to see these 4 questions raised by me earlier, the rest of the part of Evidence Act is a procedural aspect, how I do it. Now, as I said, the evidence, law of evidence can be categorized in 2 ways, oral and documentary evidence. And further, if at all we have to go further, it can be forensic, relating to these 2 things, oral and documentary. Forensic, circumstantial, direct primary, secondary, and too many aspects of it. And all these pieces of evidence need to be considered in conformity with the law of evidence. I am not saying Evidence Act, but the law of evidence. Now, we have studied the Evidence Act of 1872 or 78, which lays down the rules of proving the facts in issue, relevant facts, and we come down to section 3 of the old Evidence Act, which is termed as interpretation clause, and we deal with section 3 and other ancillary sections for the purpose of proving those facts. No doubt the Evidence Act 1872 was extended to the whole of India, including the states which had privileges. Each state had privileges so far at application, because if you have seen a bare text, you will find the state law. Simply for example, if at all I have to give, section 438 of the Criminal Procedure Code is not in operation in Uttar Pradesh. There is no anticipatory bail in Uttar Pradesh. So each states have a privileges. Similarly, the states had privileges as per the law of evidence so far it relates to. So the Evidence Act or a law of evidence lays down the rules for conclusive proof. Conclusive proof is the result. The testimony, the documents, and consistency with the case before the court lays down the rules of the evidence, which are applicable to all the courts, tribunals, forums of adjudication. And as I said, there are a few forums which do follow the principles of Evidence Act or law of evidence, but not in strict sense. As we said time and again, the evidence talks about the fact or fact in issue. What is proved, what is not proved, what is disproved, what is to be presumed, what is not to be presumed, what is may presume, what is shall presume. But what is fact? What is fact? Time and again I am saying fact in issue, matter in fact, issue. But what is fact? To simplify that, the fact means and includes anything, state of things, capable of being perceived by the senses. By the senses. Secondly, any mental condition of which any person is conscious. Now, if at all we understand this meaning, then we can go further by saying there are internal facts. Is it a new nomenclature for you? Internal facts which leads to the intention of the person. External facts, like speaking of certain words by a person. Physical facts, like sound or whatever you heard. Positive facts, like existence of will. And negative facts, like non-existence of item or object or the issue. So when we talk about the facts, all these are included in these 4-letter words. That leads us, What is relevant fact? Relevant fact have bearing upon the fact in issue in such a way that validity or non-validity of the same has bearing so far it relates to fact in issue. A person witnessing certain incident and giving evidence to that effect leads to relevant facts for this reason. Whatever he saw, whatever he executed, whatever he heard was the relevant for the purpose of that issue, whether to be proved, concluded, or not proved or disproved. Basically, I'm a firm believer of a civilized democratic society. In civilized democratic society, you follow the rules. You follow the rules till the end to come to certain conclusions. And therefore, if I have to conclude, so far as brief review is concerned, Evidence Act is concerned, I need not go to 167 provisions of old Evidence Act. Then what is new? Is the old Evidence Act is a time-barred act, time-barred enactment? I would say no. Then what is the Bharatiya Sakshyam Adhiniyam? I would say yes, some provisions which need to be added to have compatibility with present world of technology. Though old Evidence Act tried to cope up with that situation by adding, amending, but probably lawmakers thought it fit to overhaul the entire enactment with some social requirements. And that is how I won't say it's old wine in new bottle. No. It's a collection of all the relevant facts for the purpose of improving the law of evidence in the new enactment, which can be considered as Bharatiya Sakshyam Adhiniyam. As I said earlier, some people are saying that our originality is more important. What is your originality? What is the concept of your originality? If you say you have an Indian originality, if you want to refer to Vedas, that's another subject to talk about. Because no doubt we were far ahead of the world so far as that part is concerned. But don't you feel that after the British rule came into power, they synchronized too many things. The king of the state was deciding who is right and who is wrong. Was it consistent with the idea of civilized democratic society? According to me, no. If Niyati is brought before me, I am the king, with some allegation, and I don't like her face, I was permitted to punish her for whatever punishment I have given. I don't care for evidence. This was channelized in a proper way by the rule of law. And we believe, all of us, all Indians, believe in rule of law. And therefore, though we have overhauled the old enactment, we are going by the basic rules or principles of law of evidence. If we read the definitions in the Old Indian Evidence Act and Bharatiya Sakshyam Adhiniyam 2023, I would say there are many changes, much changes in my way, if at all I have to say, except the beautification of words. Like act is replaced by Adhiniyam, the word act is replaced by Adhiniyam, man is replaced by person, wakils, barristers, solicitors, attorneys are replaced by advocate. The term ravished is replaced by term rape. The term government of India is replaced by the term state. Coin is replaced by currency. Carriage. Carriage means so many things, but here carriage means car. Rupee is again replaced by currency. So therefore, we are trying to adapt ourselves to new terminology, because the crown is not in existence, the queen is not in existence, war against the king is not in existence, and therefore we have to adapt ourselves to new terminology. Now leave aside this. It's in a bit lighter way I can say that you have changed the words. But the basic things. Let us now turn to the term called admission. In Evidence Act, there is provision, section 17 onwards. Admission. Admission is a statement, oral or documentary, or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, which is made by any of the persons or under the circumstances. Now these, if at all I use this too many words, you are bound to say that it's a complicated thing, but it's a very simple thing. Let us not have the burden called complications on our head. It's simple logic. If at all it is amenable to your conscious mind to appreciate the facts in a correct way, proper manner, then in that case, yes, you are following the principles of law of evidence. But here I am not bending the rules. I am not saying I heard from this TV channel somebody is corrupt. I am not going by the another channel that another politician is a very great. Because all of us have great experience of various politicians. We need not go into that. We have to follow the rule of law. We have to believe in the rule of law. So, the law of evidence. Similarly, have a look at part 2 of the old act and part 3 of the new act. The term is common. which is called as proof. P-R-O-O-F. Section 56 of the old Act and Section 51 of the new Act are the same. Now, when we talk about the proof, we don't talk in air. We come with, and because it's your is an analytical mind, you are a rational animal. You have to appreciate the facts, and therefore you consider it to see what is primary evidence and what is secondary evidence, either in the old Act or in the new Act. Chapter 5 of the old Act and the Chapter 5 of the new Act says the primary evidence means the document itself produced for the inspection of the court to come to certain conclusions. Now though there are explanations with regard to the primary evidence, so far it relates to old Act. Considering the IT Act, there are few additions which I'll come to later on. But first let us understand primary evidence and secondary evidence. Secondary evidence is the certified copies, copies made from original by mechanical process, copies compared with the original, counterparts of documents, oral accounts. Now these relate to the old form of evidence, proof. Now let us come to the electronic or digital records. As I said earlier, we had to change ourselves in old Act, considering the change in the technology. We added ABC to old Indian Evidence Act. It was 65A, 65B, which are straightened in the Adhiniyam by 61, 62, 63, 64, 65 and 66. Now 65B, nowadays we come across in a court of law. Unless you have 65B certificate, that particular electronic document or whatever is the document is not considered for the purpose of evidence unless it is certified by the appropriate authorities. 65B says very simple, something says that the copy or the printout of electronic record can be proved only by producing certificate under section 65B4, whereas new Act allows to prove the copy or printout of an electronic record invoking the other provisions of new Act of section 63 to 65. The mode is the similar. I won't say the same, it's the similar. But मराठीत असं म्हणतात सुटसुटीतपणा. It's made very clear to appreciate and understand. If I say 65B4, man gets confused. But if I say 64, he reads section 64, whether his act is amended, whether he has amended copy of the act or not. It is simplified. Now section 61 of the Adhiniyam says that nothing in this Adhiniyam shall apply to deny the admissibility of an electronic evidence or digital record in evidence on the ground that it is an electronic or digital record and such record shall be subject to section 63. Section 63 means that it is certified as a document which needs to be considered as evidence for the purpose of the evidence. Now, we talk about yes, there are changes so far as this explanations are concerned. The major changes in this regard in New Act are assertion of explanation 4, 5, 6 and 7 in section 57, which provides for proof of contents of document. Explanation 4 speaks about simultaneous sequential storage in multiple files as a primary evidence. If you are used to these kind of electronic record, you will understand there is always a multiplication of the documents. Explanation 5 speaks about the proper custody. In the old act, whenever you prove the document, you take out the document, you first see from whose custody the document came from. Defendant is not expected to have the documents of the plaintiff, and therefore the custody is irrelevant for the purpose of proving that particular fact. Explanation 6 provides for radio recording and transmission thereof, and explanation 7 about the electronic or digital records stored in a multiple storage spaces, including temporary file as a primary evidence. Now these are the changes which need to be considered, which are added in new act, considering the change in scenario, change in the present world, and that is lawmakers have thought to make it clear, to make it easy. There is one more point which is suggested by Mr. Hon'ble, is a digital record or digital signature. Now everyone knows that the digital signature is cryptographic technique used to validate the authenticity or integrity of digital messages, documents or software. It provides a way for recipient to verify the sender is who they claim to be and that content has not been altered since it was signed. Here we take recourse to IT Act 2000, which defines digital signature. But if at all we follow this particular explanation by the Act or by the concerned provision of law, then in that case we are in a position to understand the changes in our new law, in the new scenario. I think I am not before the law students of LLB course, so therefore I need not go. There are 167 in old act, 170 in new act. The number increased because the subsections are reduced. Hardly 5 to 6 sections are increased. But I must reaffirm the fact the new Adhiniyam has not changed the entire scenario of the law of evidence or the principles of evidence, because we feel it correct to have the similar rules to prove certain facts, to reach the conclusion consistent with civilized democratic society. Now there is a last issue which is raised for my topic. I forgot one issue, that is the examination of witnesses. Now, I am making it very simple. I am the prosecutor. I want to prove an offense against the accused person. And my responsibility is this. I prove that my statement of my charge before the court without any shade of doubt. Not even a simple doubt should come to the minds of the court to disbelieve my fact. Now, while they is doing this exercise, I am the prosecutor. Leave aside the fact of now affidavit of evidence in lieu of examination chief. But the fact remains, if at all I have to prove the offense against the accused person, I am not expected to lead the evidence, lead the witness. I only want to ask the complainant or the informant or the eyewitness, yes, what do you want to say? I don't think it will be inappropriate to tell you the story which happened in the Sessions Court. A prosecution was trying to prove a fact of assault by knife. And somehow the person in the box, lady in the box, was unable to understand the prosecutor, what he wants to say. So if you have no difficulty in Marathi, it went on like this. हा भाई बोला काय झालं? ती म्हणाली काय नाही झालं. नाही घटना घडली त्या दिवशी काय झालं? हा तो अमुक अमुक माणसाला जखमी झाला. ते कसं झालं? The lady was quite a senior citizen, was unable to understand what kind of questions are being asked. So prosecutor couldn't think anything else, and he was trying to indirectly lead the witness, and doing so he said, "हा भाई काय झालं?" So judge said, "What are you doing, Mr. Prosecutor?" So he said, "I am not leading the witness." So he said, "That is not the way. By your gestures, you are suggesting something." So I am going to leave aside the lighter note or lighter side of this. The difficult task for the prosecutor is this, that you need to place your material in such a way before the court of law that the court would accept your evidence by its evidentiary value and conclude or come to certain conclusions that your prosecution case is right, not appears to be right, is right. I remember when I was a prosecutor in the High Court for some years, and though it is difficult to conduct a trial, it is also difficult to defend the prosecutor of the trial court that how these statements came on record. especially when you are appearing in a confirmation case where the accused is sentenced to the death. Because there is a prime rule is this: man is likely to lose his life because of your simplest mistake. So I have to give all my 100% about the evidence which is acceptable by rules appreciated by the Evidence Act or the law of evidence. When I prove my case before the court, or I try to prove my case before the court, it is there is a possibility, I won't say very easy, there is a possibility of demolishing the entire prosecution case by cross-examination. Cross-examination, though I am supposed to restrict myself in the particular arena, I create doubt everywhere, from the witness, from the prosecutor, from the officer. Whatever reasons given to me, I can demolish it. But to build a case, prosecution case, being in that framework of a law of evidence, shows that our law is very transparent, shows our legal system is perfect, shows we still believe in rule of law. Otherwise we would have killed Kasab on the spot. We conducted his trial. Nowhere in the world it happens. Day before yesterday you saw on BBC and CNN what happens. An attempt on somebody's life is done away on the spot. But we in India believe in rule of law and give maximum benefit. We care about the right of the accused person. No doubt we care about the rights of the victim. No doubt about it. Now there are special legislation. I don't know what Mr. Kantawala said about the Indian Penal Code, or isn't it Kantawala? But we must understand now there is a new legislation like a POCSO, where there is protection given to the girls below the age of 18, and presuming certain facts which are favorable to her. We are not expected to discuss her name in the open proceeding, which she is protected. One more aspect I must point out to you. Though we are saying about the Indian Evidence Act is repealed, changed, brought new, I am still awaiting to accept the fact what happens to Banker's Book of Evidence Act. Mr. Valve will be more concerned about it, because when you are dealing with the transaction in commercial causes, you have to look at that particular act. The law of evidence today, that is the Adhiniyam, doesn't change the sequence of examination chief, cross-examination and re-examination if ordered. If there is an ambiguity in the minds of the court may allow the re-examination of witness for a limited purpose. But in all, I would say you are practicing law, you are teaching law, you will be undergoing the same exercise with your new vision by this Bharatiya Sakshyam. Lastly, I would like to point out to you, there is section 170 in the Adhiniyam, and which needs to be clear in your mind. I will read out to you section 170. Section 171, the Indian Evidence Act 1872, Act 1 of 1872 is hereby repealed. So the Indian Evidence Act is not in existence now, it's repealed. Now you have to go by this Bharatiya Sakshyam Adhiniyam 2023. But, there is a but. Subsection 2 says, notwithstanding such repeal, if immediately before the date on which this Adhiniyam comes into force, there is any application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provisions of Indian Evidence Act 1872 as in force immediately before such commencement as if this Adhiniyam had not come into force. What does it mean? There was a confusion in the minds of police officers, and therefore it was very nice on the part of Director General of Police to create a portal and explain to entire police machinery throughout India. And it says, look here, you don't have to get scared by a new enactment. There may be some additions, but there is nothing new. What you were doing as of yesterday is still there. And when you are investigating the case, for example, by your old method, you have to continue with that because on the date of your registration of offence is prior to commencement of this Adhiniyam. So all appeals which are pending, all investigations, trial will go by the old act till it is it completes the finishing process of the old procedure. I think I made it somewhat easier for all of you to understand. We can sum up by saying, keeping the basic principles of law of evidence intact, the new act or the Adhiniyam will proceed to govern future procedural law, that is Bharatiya Sakshyam Adhiniyam 2023. Thank you very much.
Friends, as we conclude this insightful and enriching workshop on the new criminal laws, it is my honor to extend a heartfelt vote of thanks to all those who made this event possible. First and foremost, I would like to express our deepest gratitude to our distinguished speakers, Honorable Mr. Justice Sandeep Shinde, retired judge of Bombay High Court, Dr. Sujay Kantawala, and Mr. Rajiv Patil, senior advocate. Their expertise and insights into BNSS, BNS and BSA have provided us with a comprehensive understanding of these crucial aspects of the new criminal laws. Their contributions have been invaluable and greatly appreciated. I would also like to thank our esteemed guests and attendees for their active participation and engagement. Your enthusiasm and thoughtful presence here has made an impact for all of us, and it is your eagerness to learn and grow that drives the success of such events. A special thank you goes to the organizing team and volunteer students here who have worked tirelessly behind the scenes to ensure the smooth execution of this workshop. Your dedication and hard work are the backbone of our success. We are also grateful to our partners, Government Law College, particularly Dr. Asmita Vaidya, Principal Madam, for the collaboration and support in making this event a reality. It is these efforts in fostering a platform for knowledge sharing are truly commendable. As we move forward, let us carry the knowledge and insights gained today into our professional practices and contribute to the betterment of our legal system. Thank you all once again for making this workshop a resounding success. Safe travels, and we look forward to seeing you at our future events. Thank you everyone. And let us rise for national anthem, and afterwards there's tea, coffee in the classroom next door.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय